Ma Saraswati to bestow her warm blessings upon us for the success of this national event. Thank you all. Now, I request Honorable Principal Ma'am, Dr. Aarti Trehanji, for a formal welcome address. Please, ma'am.
Thank you, Rosie ma'am. A very good morning to all. Honorable and distinguished Chief Guest of today's multidisciplinary national seminar, Professor Dr. Naresh Kumar Vatsji, Dean School of Law, Galgotia University, respected President of Arya Kanya Mahavidyalaya Shahabad, Shri Ramlal Gupta ji, Vice President Shri Mahinder Kansal ji, General Secretary Shri Ravinder Gupta ji, Treasurer Shri Vishnu Bhagwan Gupta ji, members Shri Kuldeep Gupta ji, Madam Raman Kanta ji, Madam Madhu Gupta ji, Shri Manoj Bansal ji, Shri Anshul Bansal ji, Shri Kapil Gupta ji, worthy principals of different colleges, worthy guests, esteemed resource persons, worthy delegates from all over India, press correspondents, worthy faculty members of our college, members of advisory committee of the seminar, convener of national seminar Dr. Swati Atri, co-conveners Dr. Poonam Sivach and Dr. Hema Sukhija, organizing secretaries, coordinators, and all the members of organizing team. A very warm greetings to all of you. At the onset of DHE's approved national seminar on innovative trends of IPR in digital era, organized by Research and Innovation Cell of Arya Kanya Mahavidyalaya, I extend a very warm welcome to all who have joined us today. Friends, we all know that human beings possess intellect which makes them superior over other living creatures. Hence, various intellectual properties are being created in various fields of human endeavors. Moreover, innovation is a cornerstone of progress, and the digital era has unleashed a wave of unparalleled creativity and ingenuity. From artificial intelligence to blockchain, from biotechnology to augmented reality, the possibilities seem boundless. However, with these advancements come a number of challenges and complexities in protecting intellectual property rights. The emerging digital networked environment is also posing challenges to existing intellectual property law, requiring a rethinking of copyright law. The development of an efficient ecosystem for guaranteeing intellectual
Ma'am, please unmute your mic.
sorry, the development of an efficient ecosystem for guaranteeing intellectual property rights adapted to meet the challenges of digital economy requires both a strengthened regulatory environment and better competencies. In this context, today we gather not only to acknowledge these challenges, but also to celebrate the ingenuity and resilience of human intellect. This seminar is going to serve as a platform for sharing knowledge, insights, and experiences, fostering dialogue and collaboration among experts, practitioners, and enthusiasts in the field of intellectual property. Throughout our sessions, we are going to delve into various innovative trends shaping the landscape of IPR. From emergence of new digital technologies to the evolving legal frameworks governing intellectual property, we hope each discussion will offer valuable perspectives and actionable insights. So during these pride moments of Arya Kanya Mahavidyalaya, I feel highly privileged and honored to welcome our esteemed and distinguished chief guest, as well as keynote speaker of this session, Professor Dr. Naresh Kumar Vasji, Dean School of Law, Galgotia University, Greater Noida, Uttar Pradesh, and who has been Registrar and Dean Academics, Rajiv Gandhi National University of Law, Punjab also. Namaskar, sir, and a very hearty welcome to you, sir. You are certainly going to enrich all of us today with your expertise. I also express my gratitude to you, sir, for sparing your valuable time for our national event. I also welcome all the dignitaries, resource person of technical session, Madam Reema Sahni, Madam Pragati Agarwal, and delegates, media persons, and express my gratitude for being with us today. I also acknowledge the support extended by our management and members of advisory committee of the national seminar. I extend best wishes and congratulations to convener of national seminar, Dr. Swati Atri, co-conveners, Dr. Poonam Sivaj and Dr. Hema Sukhija, organizing secretaries, coordinators, and all the members of organizing team for organizing the national seminar. Let us enrich, expand, and excel for the security of intellectual property. With these words, thank you. Jai Hind, Jai Bharat.
Thank you so much, ma'am. Now, I invite convener of the seminar, Dr. Swati Atri, for presenting theme of the seminar.
Thank you, Dr. Rosie. A very good morning to one and all. I am Dr. Swati Atri, convener of DGAT approved one-day multidisciplinary national seminar on innovative trends of IPR in digital era, organized by Research and Innovation Cell, Arya Kanya Mahavidyalaya, Shahbag. I especially welcome our esteemed chief guest and keynote speaker of the inaugural session, Professor Naresh Kumar Vas, Dean School of Law, Galgotia University, Greater Noida, and resource person of the technical session, Ms. Reema Sahni and Ms. Pragati Agrawal from Innovation Technology Transfer Office, IIT Delhi. Chief guest and keynote speaker of valedictory session, Dr. Nitin Goyal, Assistant Professor from Central University, Mahendragarh. Delegates joining us across different parts of the country and the members of the press. I would also welcome honorable members of the Management Committee, our worthy principal, Dr. Aarti Trehan, members of Organizing Committee, teaching and non-teaching staff of the college. As the convener of the seminar, I feel privileged to deliver theme of the DGHE approved one-day national seminar on innovative trends of IPR in digital era, where we embark on a journey to explore the innovative trends shaping the landscape of IPR in the digital age. I stand before you today with a sense of enthusiasm and anticipation as we delve into the complexities of IPR in the digital era. The digital revolution has ushered into the unknown opportunities and challenges, transforming the way we create, share, and protect intellectual property. In this dynamic environment where ideas flow across the borders and platforms, it becomes imperative for us to understand and adapt to the evolving trends in intellectual property protection. Today, we gather here with the shared objectives to unravel the complexities of IPR in digital era and to explore how innovation is reshaping its landscape. Our seminar serves as a platform for an interdisciplinary dialogue where experts from various fields converge to exchange insights, ideas, and best practices. At the heart of our discussions lies the theme of the innovation. As we navigate through the digital frontier, we witness the emergence of groundbreaking technologies such as AI, blockchain, big data analytics, each presenting unique opportunities and challenges for intellectual property protection. From protecting software algorithms to safeguarding digital content, the realm of IPR is undergoing a profound transformation, demanding the innovative solutions and strategies. Moreover, the digital era has blurred the traditional boundaries of intellectual property, giving rise to the new forms of creativity and collaboration. Open source movements, crowdsourcing platforms, and collaborative innovation networks are revolutionizing the way knowledge is created and shared, challenging conventional notion of ownership and exclusivity. As we embrace these disruptive trends, we must try to strike a delicate balance between the fostering innovation and safeguarding the intellectual property rights. Throughout the course of the seminar, we will explore the myriad of the topics ranging from the implication of artificial intelligence on patent law to the challenges of enforcing copyright in the digital age. We will delve into the case studies, engage in interactive sessions, and hear from the esteemed speakers who are at the forefront of innovation in their respective fields. This one-day national seminar serves as a testament to our commitment to advancing knowledge and fostering collaboration in the realm of intellectual property rights. We are honored and excited to have such an esteemed dignitaries and more than 150 delegates who have joined us throughout from the different parts of the country. As we embark on this intellectual journey together, let us embrace the spirit of innovation and collective learning, paving the way for a future where creativity flourishes and intellectual property rights are safeguarded in the ever-evolving digital landscape. Thank you. Thank you so much.
Thank you so much, Swati ma'am. Today, it is our honor to have Dr. Naresh Kumar Vasji as our chief guest and keynote speaker. Now, it's time to introduce our today's distinguished chief guest, Dr. Naresh Kumar Vasji, to all of us. Sir, presently working as Dean School of Law at Galgotia University, having 37 years of teaching, research, and administrative experience in higher education at national and international level, university and college in the field of law, that is Rajiv Gandhi National University of Law, Punjab, Maharashtra National Law University, Nagpur, National Law University and Judicial Academy, Assam, BGC Trust University, Bangladesh, Kurukshetra University, Kurukshetra. He has worked as Professor of Law, Registrar, Vice Chancellor, Chairperson Advisory Committee, Chairperson Curriculum Development Committee, Director IQAC, and much more. Sir has been chief editor of 5 volumes of prominent law journals and published 36 research papers in famed law journals and published 25 books. Some of the selected titles of the books includes Emerging Trends of IPR, Patent and Traditional Knowledge, Policy and Practice, Artificial Intelligence and Conflict Resolutions, and much more. Sir presented more than 130 research papers at international and national platform seminars and attended a lot of workshops, lectures, and courses. He has supervised 80 LLM dissertation, PhD, and postdoctoral research at various universities. Professor Watts is also a member of various institutions, academic council, executive council, general council, research advisor committee of various institutions, including lifetime member of Indian Law Institute, New Delhi, and Bhagwan Parshuram Education Society, Kurukshetra. Sir, your expertise and insight would bring immense value to our seminar. Now, I request to Dr. Naresh Kumar Vatsji, our today's inaugural session chief guest and keynote speaker, for sharing knowledge and valuable thoughts on digitalization of intellectual property rights and traditional knowledge. Please, sir.
Thank you, ma'am. And at the outset, I appreciate the concern of the college management team of Arya Kanya Mahavidyalaya, Principal Dr. Renu ma'am, and the management members, President, General Secretary, Vice President, Treasurer, and all the faculty colleagues whose effort would at least seriously join hand on deliberation on this particular theme of intellectual property. With the experience as academician as well as administrator, I could understand and evolve the development of the understanding, education with regard to the IPR, specifically in the northern region. Somewhere we are somewhere at the back seat, either in the education or somewhere its implementation of the intellectual properties. Dr. Swati, my PPT, whether it is visible?
Yes, sir. It's visible.
Please, it's my humble request. If at all my PPT is not moving, please just apprise me.
Sure, sir. Sure.
Might be some, because this is the flaw of the this internet era. So the topic which we are here to discuss with regard to the IPR, the traditional knowledge specifically, and then the digital era, as we consider the traditional knowledge is the foundation of intellectual property, and in the modern era, particularly maybe with regard to the economy, across the world, the intellectual property is dominating. The developing countries, developed countries, or underdeveloped countries, somewhere they are not able to harness all the skills, inspire the people, inspire the residents. They have a lot of skills, but it's implementation, but it's exposition, the protection, that is the very serious concern. Usually we talk of the intellectual property, specifically the copyright, the patent, the trademark, design, geographical indication, trade secret, layout of designs, on many. But essentially, maybe the copyright, maybe the patent, maybe the trademark, they all revolve, they have the interface with the traditional knowledge. And what we understand about the traditional knowledge, that is varying from the society, varying from the culture, and the challenges what we have today, of its preservation. Sometime because of the fear of either stealing the traditional knowledge, or sometime insecurity about the loss of the job, insecurity about the profession. But on the other hand, later or sooner, when the traditional knowledge is disclosed or digitalized, so sometime at least we are at the safer end. And therefore, repeatedly, at many conventions, it has been deliberated that at least the traditional knowledge, that should be digitalized. When we talk of the traditional knowledge and the digital library, otherwise, when we discuss at the different corner of the state, so the traditional knowledge that vary, and it's a little difficult to understand or to our to know whether it is pre-existing or not pre-existing. So firstly, I'll be discussing about its interface of the traditional knowledge, how we can digitally maintain or ensure the digitalization of the traditional knowledge, because somewhere either the particular sect of the society, they are not able to transform, they are not able to transmit their traditional knowledge. So therefore, it is not the person who are having the traditional knowledge, but with the help of the government representative or the society, we can just go ahead for its digitalization and stopping the wrong intellectual property in the wrong hands, and to stop it, that unjust enrichment of the unjust enrichment because of the traditional knowledge or the intellectual property. When we discuss the traditional knowledge, the digitization, it's a collective rights that belong to the community. It is not of the individual, but the traditional knowledge is related or considered to be the collective rights or the collective knowledge of the community, maybe of the particular family, maybe of the particular the group of the society. So that is known as, and therefore, because of the protection, because of the digitalization of the traditional knowledge, maybe for the practices, maybe for the instruction, so that can be even digitalized. The processes or its the instructions or the processes, so that can be digitalized, and with the help of this, we could at least stop the unjust or wrong patenting, that wrong intellectual property, like in the US trademark office, they try to got the patent of the turmeric. Actually, they try to got patent of the name. They try to snatch the even the basmati. So these are the many things, very landmark cases where with the help of the traditional knowledge we could stop it, because every sect of the society, they understand and they know it, that how to use the name of the turmeric, how it is applicable for the medicinal purpose, or the name, how it is applicable, or otherwise, like even basmati. So if we remember that the senior person or of my age or even senior to me, so how the turmeric is used for the medicinal purpose. So even the neem leaves, how they can be used for the skin diseases. Even the basmati. The basmati is not grown in at any place. It is only possible that you can plant the basmati, which give you the flower, which give you the different taste. And different is somewhere that is in the Gangetic region only. So ultimately, we could stop it and we could at least preserve the heritage of the Indian basmati. And almost we consider it, that is the property. Almost when we discuss about the patent related, the TKDL, Traditional Knowledge and Data Library, with regard to the patent. So patent is such a thing actually that it is not everybody. Sometime my friend usually talk actually that you get the patent. Patent, everything cannot be patented actually. Patent is usually taken into the patent that is maybe for the engineering, or maybe for the especially the processes, maybe for the even technology. So section 3D or section 3 specifically of the Patent Act that specify which cannot be patented actually. Otherwise, the qualifying criteria is there that when you are going for the patent, then at least the novelty, inventive step, or somewhere utility. So with 3 criteria are there where we can think of, we can discuss, okay, yes, this is the item that can be patented. Even when we discuss about the traditional digital knowledge, I am discussing the traditional knowledge. So there is one particular specific element that when we discuss the first element of the novelty. So what is novel there actually for getting the patent? Whether that is the new, and novelty means it is not new to you, new to across the universe, across the world actually. So that is the novelty we are discussing. And when anything like the name, use of the name, use of the turmeric. So if the name and the turmeric is used by the traditional knowledge, so one cannot think of getting it patented. And if somebody is trying to patent it, so that way that can be considered, okay, it's a wrong patent in the wrong hands. So unjust enrichment of it. So therefore, that says, okay, if it is not new, because our traditional knowledge, our society or particular sector of the society, they know how to use the name of the turmeric. So that cannot be patented, and that will be out of the section the Patent Act for getting the patent under section 2. And with this help, that is surprising that when we started the digitalization of the traditional knowledge in the digital library, so with the help of the digital library, India is able to counter the 36 patent application in the Europe. More than that, actually, it's a particularly Europe. So it is even more than that, where we are able to stop it, and we have even got the even signatory of the international convention with the different countries. So that is one part. On the other hand, when we discuss about the copyright, again, that is also other than the patent or the trademark, the copyright is also related, is directly or indirectly, it is related with the traditional knowledge to you. So when we discuss about the copyright specifically, that is like the artistic manifestation. So here the copyright discuss about the artistic or dramatic or literary word actually about the copyright. But here specifically the artistic manifestation. If somebody is skilled in a particular artistic pattern actually. So that is with the traditional knowledge only. Like the sometime the mason, like sometime even the craft or the artist, they are able to use that particular the traditional knowledge. So that belong to the indigenous community or the migrant people actually. So they cannot exclude themselves, and otherwise if sometime that is in the wrong hand, so that is a kind of the abuse of the traditional knowledge. Like the literary work such as the stories or the legends or the myth, custom, poem, theoretical work, or the pictorial work actually. So that can be. Or the textile work actually, it is within the particular society, the traditional knowledge of that particular textile work, like the fabric, only a particular group that can do, or the clothes weavers. So only the particular society or particular group of the society or sect of the society, textile, even the composition of the tapestries or the carpet or the musical work. So that is restricted only particular, not everybody, but only it is a particular segment of the society. So three-dimensional work such as the potteries, we have the different categories of the pottery makers, ceramic makers, or the painters, or the wood, stone, carving. So different the works are there actually that can be even taken care by the particular group of the society. And when we discuss about the traditional knowledge, digital library with the trademark. So again, the trademark, that is the consumer perspective actually. So that is even considered the like particularly one particular trademark, the collective mark. So collective mark that can be used as a secure artisanal and the cultural product. So when we are coming in the certification of the mark, so that may be used to distinguish a wide variety of the product and the services, transitional art and the art wood or the food, clothes or the tourism. So certification, that is only and only when we go for the mark of the certification mark, like a Kullu salt. Kullu salt. So salt is of course, that is geographical indication, but the kind of the certification to that particular mark is given by by particular agency only, or the collective mark means thereby yes, a particular group of the trademark holders, they just come together, not in the partnership, but collectively of the particular profession or the particular trade. So that way, this the traditional knowledge help in protection of the trademarks too. Even use of the trademark can certainly establish the product, the fidelity, and protect against the reputation loss resulting from the use of the traditional knowledge. If somebody is misusing it or sometime abusing the fidelity, so that way that can be even protected with the help of the traditional uh, knowledge. Even the geographical indications. So geographical indication, again, it is closely related with the traditional knowledge, because we are talking of the patent, we are talking of the trademark or the copyright. There we can say it is the intellectual property in the name of an individual, one individual, or a person actually. But with regard to the geographical indication or the traditional knowledge, so these are the community intellectual property. Actually, it is not of in the name of the individual. So, but the community together. So they work actually and they own it. So therefore, this geographical indication here it very closely related with the traditional knowledge. Like when you go for the agriculture goods actually, or the natural goods or the manufactured goods, everybody, every sector of the society, every person of the society, they cannot be trained for the agriculture work. They cannot plow actually. Everybody cannot plow. Everybody cannot be the agrarian class. So therefore, it is the particular agrarian class. It is only the farmers. They know how to do the agriculture, how to seed, how to what to plant, and what to when to give the watering, when to harvest. So that is their specification, their knowledge actually. And what should be the kind of the soil, and what to even spray, or sometime use the termites, or use the sometime the fertiles. So that depends on. So they have the skill, and therefore the agriculture goods, they know it, or the natural goods. Even the natural goods, they know, okay, how to protect, how to use it, like the particular stone, like sometime particular say the processing, even the processing. So even somebody has to go for the process the brown sugar, process the even the sugar can into any of the form, the sugar, or the some the good, or some other the sweets. So everybody has their own style of its manufacturing and the processing. So therefore, it is very closely related with the geographical indication, and that is only and only associated with the particular community actually. And this particular geographical indication, so that relate with the region actually, with the particular territory. It is not that you are able to crop up the basmati in Haryana or Sahabad or Panipat or Kurukshetra or Taraudi. So because the basmati which is grown in Taraudi, basmati grown in Dehradun might be the different actually, or sometime basmati grown in Assam, basmati grown in, so they cannot be given the name of the basmati then. The rice means different. So therefore, it is presumed that the basmati is grown only and only near and around the Gangetic region. So this is how the particular the traditional knowledge is working with the geographical indication. Again, we have the trade secret actually. So how it is related? Yes, of course, we had been discussing. Okay, sometime because there is a hitch in the minds of the traditional knowledge, the society that vested with them, and they are having the kind of the agitation not to reveal and not to discuss the particular process of the traditional knowledge, or to process how to manufacture it. So therefore, there is a provision that you can continue and maintaining the trade secret. But here, as such, we do not have any law for the maintenance of the trade secret, or otherwise somebody leak or somebody just manipulate the trade secret. So you cannot prosecute anybody then. We do not have the law, dedicated law, only and only that you can just enter into the agreement. Okay, you are within that agreement, and you are doing this particular kind of the work so long as we are together. So that we are bound by the contract. But moment the non-disclosure agreement, the moment you break the knowledge, break the agreement, so only then only that can be the punishable. Otherwise, we do not have specific law other than that, like the Patent Act, like the Copyright Act of the traditional knowledge, so the geographical indication. So we do not have other dedicated law for the trade secret. So therefore, so long as you continue, that is very wonderful. You can continue enjoying the benefits of the traditional the trade secret. Moment the trade secret is open, either it comes in the public domain, so you lose everything. You cannot go for that. So rather than that, that's way actually we are discussing usually. Say rather than maintaining the trade secret or the secrecy, so better to go for the registration, go for the patenting, go for its protection either through the patent or through any of the applicable the intellectual property right. So that way this work. On the other hand, now if we go ahead individually the trade secret, the intellectual property. So I will be discussing about from the traditional knowledge that little bit an overview of the intellectual property, like the copyright, which is very specifically related to all the luminaries, educational luminaries, or all the fraternity of the education, academic fraternity actually. The copyright. This copyright is discussed here. The copyright Is it visible? Hello.
Yes, sir.
Swati, my PPTs are visible to you?
Yes,
Yes.
sir.
Yes, please. Thank you. Because I need to just recheck it. Yes, please. So therefore, when we are again going for the intellectual property, specifically the copyright is that domain actually which everybody and every student and every even the uh, scholar, they are expected to understand the consequences of the copyright. The copyright here we usually say the negative right actually, and how it is negative right, that negative right is that you stop somebody to not to do, not to copy, not to use that right actually. So that is the negativity actually. Means because that is your domain and you continue using the particular copyright, maybe the literary part actually, literary work. And under the copyright, we usually say the legal rights over the intellectual creation. That intellectual creation, how you create it, the originality, maybe the scientific work, industrial. It is not industrial work, but it is considered as a literary work, or the artistic work, or otherwise a dramatic work actually. And there we consider that the copyright is in the literary, artistic, dramatic, or filmatic work. And there we consider that it should be the original one. And the originality, it means originality, we have the criteria of sweat bro principle actually. At least you have put your labor, you have applied your mind, you have even labor and worked on that particular domain actually, on particular creation. So that's sweat bro principle is there. So there the literary work such as the novel, you are writing some novel, some theme based on your the outcome, based on your experience, based on your even the exposition. So that literary novel, poem, or the play or the dramatic work. So that is falling under the literary work or the artistic work. So maybe that drawing, how well you paint it, how well you paint it, or the drawing, or the photographs, or the sculpture, or the music. Now, specifically, I usually discuss about the photograph actually. How the copyright you have? Can you have the copyright of a photograph? In which way you can have the photograph copyright? It's like you are going. Nobody stopped, of course, getting drawing the photograph or taking the photograph of Taj Mahal. Nobody stopped. But how beautifully, how nicely you take the photograph means keeping that somebody is carrying the Taj Mahal in hand, or somebody, or otherwise somebody, you are making somebody to sit on Taj Mahal. Means the way means which it liked, or it that is your creation. So that is considered, okay, yes, this is considered as a copyright of your. But provided, again, the principle is, okay, if you have paid, you are paid, or you have paid for it, then you do not have the copyright. The person to whom you have paid, he will be having the copyright of that particular work. Actually, like we are working in the institution and something created in the institution by using the infrastructure, by using the aid and the resources of the particular institution. So there we consider, okay, yes, that is subject, that there is an agreement. If there is an agreement, okay, you carry on doing it. But otherwise, if there is an agreement, okay, yes, you create it, that will be the copyright of the particular institution. So there, that will be rested, that will be restriction actually. Here, the copyright will not be our, the copyright will be of the particular institution. On the other hand, the cinematographic film or the sound recording, so that is also one part of the copyright. So here are the some examples actually. Here are some examples, like the literary work or the dramatic work. Actually, somebody is composing, somebody is writing and doing some act, or some musical work. If somebody, you play the music, actually the music without any the fixation of the words or the notation. No. And even the typographical work of the writing, that same writing, or some art or artistic work, so that is considered as a copyright provision actually. On the other hand, we have, see, that is directly involved with the particular individual actually, that you are the individual and you are writing or you are doing that particular work. But on the other hand, when we discuss about the second right, that's related to the neighboring right actually. Here the neighboring right is the particular performance, the performer's right. And you as a performer, you as a performer, you as a performer is like you play the role as a hero or the heroine or sometime as a singer even. Singer. So you are using your voice, your throat, or you are playing, you are acting, you are doing something. So that is the second right of that is considered as a neighboring right. Performing arts producer or the phenomenon or the broadcasting organization means the broadcaster is taking all the essentials together and beautifying and doing and the broadcasting after cropping and every re-editing. So that again you have the different rights. So you may be having the industrial property too. One is the non-industrial property, which we consider the copyright. That is not an industrial property. And then the IPR, again, we discuss the industrial property, which are considered as the patent, the trademark, the geographical indication, design, layout design, protection of the undisclosed information, include trademark, trade secret. So these are the industrial properties, and the other ones, the copyright, particularly specifically, that is not the industrial property, actually, that is a non-industrial property, which we consider the trade copyright. So these categories of the intellectual properties are two. One is the industrial, the other one industrial separately, which is governed by the Paris Convention, but non-industrial, the copyright specifically by the Berne Convention. So Berne Convention takes off the copyright, and the Paris Convention, it deals with the industrial properties. And the industrial property here we consider that industrial property which can be used and which can be ensured that the workable as well as the patenting of the processing actually. So that is the industrial property. Like the artistic work, here we consider that sculpture, artistic work, painting, sculpture, drawing, diagram, chart, or the work of the sculpture, which include the engraving, etching, lithographs, wood paints, photographs, and sound recording. Sound recording means merely the sound recording, like sometime somebody is good playing the instrument of the creation of the sound recording. So it is a background music. Sometimes you find soothing, then while working you find some background noise, background music actually. So that music, that sound, that recording, that can be considered as the sound recording. Here the lithograph is there. Lithograph means somewhere the oil painting or somewhere you are working or some on some metal work actually. So that can be even considered the artistic work actually, which that is a part of the artist, and it is falling in the domain of the copyright, even the etching. So beautifully that the work, the artist then scratches off the grounds with the pointed etching needles. Means how beautifully they have needle, they have just given the shape on the metal, bare metal. Secondly comes to the trademark actually. So you understand that the trademark, everybody is I think the consumer, everybody is the consumer. consumer, the consuming here. How do we know that? Toothpaste. Can somebody ask, can somebody think of, okay, what is the toothpaste? Maybe the variety of the toothpaste actually. Why specifically? Otherwise, usually we say, get me the Colgate. Colgate means that indicates the toothpaste, and the message to the consumer, message to even the users or even to the grocery shop. Okay, yes, we need the toothpaste. The Colgate. Colgate is a brand actually. Aqua or the Sensodyne or the Clotha. Or otherwise Whirlpool machine, washing machine. It can be washing machine, anything. Any name is there. Yes, Kiran. Kiran is there, I think. Kiran, I think you raised the hand. Kiran Jyot.
So you may continue. It may be,
Oh,
yeah, it may be some mistake, I think.
okay.
They have raised the hand.
Might be mistakenly probably. Yeah. So we have the different the trademarks marks which represent the particular class actually, represent the particular product or the services or the mobile, even sometime Nokia, the Samsung, or many things actually. Why do we like Nokia is one trademark, Samsung is a one trademark, or otherwise laptop, Dell, HCL, Micromax, or otherwise like sweet. Why do we talk of the Haldiram then? Why do we talk of the Pikane or Chitali Bandhu, or a beverage, Coca-Cola, or a Pepsi Cola, or Rashna, or the fruity? So the flight means airlines only. That means somewhere at least it is providing the service, or other Emirates, Lufthansa, or Indigo, or otherwise Dabbawala. So how many knows the Dabbawala? If say Dabbawala, that is the kind of the services provided, service provider actually, and that is known actually for the services that at least the first, at least the hygienic and the quantified specific quantity of the particular product that can be even, or the like we discuss about the insurance. If somebody knows how dominating the LIC is, means does not mean that LIC is the only dominating one actually. LIC is only means maybe when you are going for the insurance. So maybe when you are going for the insurance, so you go for that you are going for the LIC. LIC means may not be that particularly office of the LIC, but maybe for the ICIC, maybe for the SBI, maybe for any of the organization. But usually we say that the person is going for the LIC. It is not specifically indicating the LIC office, life insurance corporation. It's independent. One tag is there, one particular service or the service mark is there. Or the car, Maruti, maybe the Hyundai. Previously we know only the Maruti. Maruti is the only, or otherwise Honda. Honda, not only the Hero Honda, but also the car. Nissan and BMW. Or the footwears, or the Nike, Liberty, or Relaxo, or many more. The service providers are there actually. Many more products are there which we usually consider, okay, yes, these are the particular product. So therefore, for protection, just to identify as a teacher or as a the student of the IPR, we must ensure that whenever we are using any product, we shall see that these marks are indicated. This particular TM means it is not yet registered trademark. It is just they have applied for it. It is not completely. It can be denied, it can be accepted. And once it is accepted, so that will be again R encircled. So this mark you will get. Or about the service like Dabbawala, like the even insurance, so you will get this SM service mark. So that is the indication for your remembrance that when you are consuming anything, water bottle or sometime any of the eatable products, you find it's a brand. Brand means you will get the registered one or the TM of the asset. So this indication that says yes, it is a registered one, and you are liable to even seek the claim in case it does not satisfy your need. It does sometimes injure you. So you can just prosecute the organization or particular proprietor. So these are somewhere the trademark which you consider. Why do we talk of the trademark? Means that capable of being the represented graphically. Means somewhere when we, as a student, we discuss it should be represented graphically, because we are in the techno era, we are in the digital era. So today is not the time actually that you can just open the grocery shop and your grocery shop is limited to Sabad or Kurukshetra or particular area of Greater Noida. No. Means when particular trademark is distinguishable and it is able to represent graphically, so thereby means that we can across the globe we can share our shop. Means that is e-shop. So e-shop means from the any corner of the world, when you are on the domain, the internet. So person sitting at one corner of the country, they can access to this domain and they can just find out the desired product. Like sometime you are sitting at a particular place and you seek any services of the Amazon, Flipkart. So you do not know, and he does not know you actually. Only thing when you place that order, so when you place the order, then only that particular product will be available to you. That can your desired product will be available to you as and when you need it. So there was section 2ZB that says trademark means the mark capable of being represented graphically. Graphically means that is digitally that can be represented, and which is capable of distinguishing the goods and the service. So how I could make the different here, if we see this Colgate and Aqua, how the Colgate and Aqua are different. Of course, the purpose of the Aqua is the same, that is toothpaste. But Colgate and Aqua are the different. They can have their own brand, or Maruti, or otherwise your Hyundai. They have the different brand. The purpose is getting the car, getting the particular four-wheeler, or sometimes the nowadays. So that is the reason K, which the purpose is it should be able to distinguish the goods and the services, that this is the particular product of the Hyundai, this is the product of the BMW. So that does not confuse the consumers. K, no, otherwise simply one kind of the things that can be like a Maggie, one can understand K, yes, it is the different, or the Pepsi or the Philips. So that kind of the trademark that can be there. Sorry. So it make you to distinguish from the one goods and the other goods and the services of the other services, but maintaining that quality. It shows that yes, the quality of a particular product is the different and even as desired by you. So that if you do not compare the quality, sometimes non-branding product that can be purchased. Sometimes, like the certification mark I was discussing, even this certification, that certification particular agency, it give you the certification. Okay, yes, sometimes you find the ISO. ISO is given by the particular organization. 2001, 201, or 1000, or 100000000. So any of that particular ISO is given by particular agency, or otherwise, like you say, the NEC accreditation or the NIRF ranking. So that is one kind of the certification. The certification is given by particular organization that we are able to certify and you are qualifying this particular the standard. So you are able to meet this standard. So that is the criteria. That certification mark is given by the particular agency, and that is for the limited period. And time to time, the certification, of course, the NEC and the NIRF or sometime NBA, they go for the certification yearly or 2 yearly or 5 yearly. But this particularly the certification mark given by them, the particular agency for the product. So there is a need that they must restrict this certification for a particular period. Like the collective mark means the trademark distinguishing the goods from services of the member of an association of the person which is the proprietor of the trademark from those of the others. So means you are coming to the collective mark and your product and the services are the different from the others. You come under the one umbrella, so you will be different from the other mark actually. Like the trademark, you say the brand name, a synonymous of the trademark, distinction of the indicators. So there you find the logo, like here Volkswagen, you find here the Apple, the Twitter, or otherwise the Adidas or the Nike. So different indications. So even from this indication, you understand hamburger, you understand Volkswagen, you understand the particular mark actually by mark. Yes, this is dealing with the particular the product. So uniqueness and the distinction. So that is there actually. Like this Karlo Duniya Mutti mein. Another even not only the particular product but even the phrases. Having the trademark, that is also attracting the copyright even. Copyright is the trademark both that can be given to a particular mark actually. Like Karlo Duniya Mutti mein. Even the literary work is there. Literary work is there. You have done it. So that is like the Geo. When Geo started, it's global India. So that way, that trademark is given. Even the deceptive similarity. Sometimes you may find the deceptive similar product actually in the market. And as a deceptive similar, the purpose is to ZA, that says, okay, at least the mark should be different from the one company to the different goods of the other company. Services of the one company from the services of the other company. So how you are different, but sometimes you find the different, very deceptive similar, which even you find confusion actually, the confusion, and sometimes you find simply if I give the word Colgate and Colmate, means here only the word difference is G and M, Colgate and Colmate. So means phonetically it is similar, constructively it is almost similar, that sometimes the packing is the different. So somewhere the deceptive similar product that can be even Bismari, or Bilsari. So somewhere the word here and there that can be substituted. So that is causing confusion, and it is unjust or deceptive similar for making the consumers confused actually. On the other hand, like the mark, which can considered again, that can be the device too, that can be brand too, that can be heading, or the level, the ticket, or the name, or the signature. Even your signature, that will work. Even your word letter, the numeral or the shape, or any color or the color combination, that can work. Like the Docomo, you see color, the combination of the color, Docomo, or the today which you say that is Tata. So almost the color combination, or SBI, you have the color combination, or Axis, you have the color combination given. So color that can be given, that is another mark which is indicating the services, indicating the particular trademark. Or the packaging too, even sometimes. The packaging, maybe the box or the container or covering the folder or receptacles. So you find the different the trademark which catch your eyes and give the impression to the consumer how this particular work or particular product or the services are suitable to you. So that can be there. Like here the Apple. Anybody, is it? Which one is correct? Apple, about the apple. The green or this one? Green or the gray? Or McDonald or McDonald, or this Nika or this Nike, or this Puma or this Puma. So which one you feel, which is the correct one? So this kind of the confusion sometimes may arise in the mind. So this is dominating and this is prevailing in the market actually, and it is just causing confusion because sometimes even the proprietors are least bother for it. Proprietors sometimes they do not bother for the survey, they do not bother even just go for that. But until unless you as a consumer you get trap of the particular product and you get confused and sometimes it which injure you. So you go to the court or the consumer court. Sometime then only the even proprietor will be there. Otherwise, proprietor will not be there. So that is the confusing part actually on the at the level of the proprietors. Even sometime like the geographical indication, you find that I was discussing the geographical indication because it is now the coming on the community engagement or the community intellectual property actually. How the community is engaged in developing that particular intellectual property. Maybe the agriculture product. Darjeeling tea, everybody knows the Darjeeling tea actually. Everybody knows. Means it shows that the tea which is only and only grown in Darjeeling, not anywhere else. So that tea and that give the different taste actually, that give different flavor, that give different color. So that is the Darjeeling tea, and that is how the agriculture, this agriculture product as a geographical indication, it has been considered. Or the West of Bengal, Muga silk, the product in Assam or the eastern sector actually, of the rice basmati grown in Gangetic Basin. It is not grown everywhere in the country or or any corner of the world. No, it is not. That is the reason that basmati is grown only and only on the Gangetic Basin. Because basmati term name is the tag, and it has the different flavor, it has the different taste, it has the different length and the breadth of the rice seed actually. So that is how this particular Punjab, Haryana, Himachal Pradesh, Uttarakhand. So that is even the Kullu salt. The Kullu salt, that is Himachal. This salt, the salt or the wood which is taken from the particular animal, and that animal has the endurance to stay in the particular temperature. Then only that wool is taken from the particular wolf. That is the reason the Kullu salt. The Kullu means a particular because of they had a very low level of the temperature and they are able to survive within that particular temperature. And the wool taken from that particular animal. So the sole is grown, sole is made, woven from that that particular wood. So that is how the Kullu salt. Otherwise, if you take the wool from the near and around the sea, and you give the tag of the Kullu shawl and how to weave it, sometimes it is difficult, and we will be in the clutch of the infringement actually. Even the Swiss chocolate, because it's just Switzerland. It is because the temperature, because the particular stuff, particular product, or the even cream, or sometime the material, other processes that is available easily there. Alfonso mangoes, or the LP green cardamom, or the Kanchipuram sari, or the Kolhapuri chappal, is thereby that these are available. These particular weather is conditioning, weather is friendly. Then traditional knowledge is also there. Then the particular the processing is also there, as well as even the raw material which is available from there. So that can be easily available there actually. Either maybe taking for the LP green, maybe for the Alfonso mango, maybe for the Kanchipuram sari or the weaver. So that is how the even the geographical indication as an individual or as a student or the teacher, we shall understand it. So there some green area, geographical indication like in the Maharashtra, Marathwada, Kesar mango, or Dhanu Golwat, Chiku, Dhanu Golwat Chiku. We have also Chiku, but we have the different Chiku actually. We have the different mangoes. Jalgaon banana, how it is banana, why Jalgaon banana? Means somewhere some peculiarity is there of the banana. Or Mulsi Ambedkar rice, like here the Basmati. So there they have Mulsi Ambe Moha rice or Bhiwalpuri chili or the chili particularly in this Assam. That's a very small chili actually. So they have joined in 2016 as geographical indication trial. It took 3 years for struggling, and ultimately they got the this tag of the geographical indication. Devgarh Taluk Mango Growers Cooperative Society, the geographical indication, and Alfonso Mango on Devgarh means thereby like Sindhu Durg means somewhere the mango is of almost one mango is weighing somewhere say 400 gram, one mango actually. Like when we compare these geographical indication in Haryana, in Punjab, so we are very backward actually. Honestly, we are very backward on protection of the geographical indication. We have only and only 2 geographical indications in Haryana, like Basmati, that is well known after a lot of dispute. Then the Fulkari. Fulkari is of course not our original product, this one, but somewhere at least like Rajasthan and Punjab. So these are the area, those are dominating in the Fulkari, but in Haryana, very rarely. And like here, the gray areas are there. The gray area like the sweet, the firni, undri, firni, undri wale hai, jo ghevar hai, firni hai. So that means many things are there because they are grown only and only within that particular the season actually, and only that particular society, nobody else. We cannot grow, we cannot prepare, we cannot process this particular this. Yes, Kusi is there. Kusi, anything you want to say?
Sir, I think it is by mistake, sir.
Okay, no matter. So my purpose is just to have the deliberation on the protection of the geographical indication, even in Haryana, even in Punjab. So that way we can just go ahead with it. Even the revisit to geographical indication like geography, agriculture product, natural product, agriculture product. What we are growing, what is left, like the natural product, what we have in Haryana, in Punjab, or otherwise manufactured product, like especially in Pundri. In Pundri, I gave you one example of the firni or the ghevar or many sweets, because it is grown within the only fermentation of the particular the processes, or otherwise like the jalebi of this one Sonipat wala, क्या नाम है उसका, कौन सी जगह है सोनीपत के पास में,
Mathura Malwai, sir.
गोहाना जलेबी, वो आधा किलो
Mathuram है, sir.
हाँ जी, माथुराम, करेक्टली माथुराम की जलेबी. हाँ, सो मीन्स समवेयर एक पाव के आसपास लगभग एक जलेबी आ जाती है. Only 4 jalebis you have. Even like Panipat is a very strong hub of manufacturing actually. So no, we do not have the geographical indication of the Panipat this one chatai or something, so khadi work. But we have the geographical indication of the different area of the Uttar Pradesh of the similar kind of the fabric. That's a very unfortunate actually. We are not able to, either the government is not able to protect promote it. So thereby sometimes the reason is we are not able to protect it. So that is unfortunate. So there, like the recently the High Court of Uttarakhand actually, that's a very great work they did actually. And the great work is, on the other hand, that says Yamuna and Ganga River and the Yamuna River, they have been given the tag of the living entity. It is not something else. Of course, the community, it is the geographical indication because they are flowing within that region actually. They emerge from there and they sometimes spread over the country. So that water means Ganga Jal and the normal water. Means particularly when we think of Jal, like in West Bengal, they term the Jal. हम पानी यूज करते हैं उसको, हम पानी बोलते हैं उसको। तो बोले कि पानी नहीं है ये जल है। और जल का मतलब यह है कि दैट इज द प्योरिटी विच इंडिकेट द प्योरिटी। गंदा पानी भी होता है, गंदा भी तो होता है पानी ना, विच यू कैन नॉट ड्रिंक। So therefore that is considered a jal, Ganga Jal hai, and you take the Ganga Jal, and the best part of the Ganga Jal is that you drop it in any of the water, so that becomes so pure, and sometimes it will not stink for many months, and that will survive, that will last long for many months actually. That is the beauty of the Ganga Jal. But otherwise, you take the other water, sometimes you will find a lot of worms there, you will stinking, and not many things are there. So that cannot last long actually. So that is the beauty of this Ganga Jal, and at least that's appreciating on that part. Actually, the Uttarakhand High Court, they have taken in tune with the New Zealand. New Zealand pronounced the largest river here, that says Wang Noi declared the living entity, and similarly that in tune, Uttarakhand High Court, they gave the living entity and Yamuna and the Ganga. So therefore, we need to draw with a wider interpretation of attracting more protection of the geographical indication, and must be even the water, stone, earth, and the salt. So many things in Haryana and the Punjab, like the Murrah buffaloes. Murrah buffalo, which you find the cow, even the surprising, in Kerala, that is Palkova. Palkova is the one sweet actually, which is considered as a the geographical indication. Pal is milk. Pal is a milk of cow actually, and the kova is the sweet. So the cow milk sweet actually, and that's a geographical indication because the cow is very small cow there, but we have very large, very big cow. So if we have that capacity, so at least many things can be there, and we can just think of its production. Maybe even the demise, even the carcasses used, any product which is used from the carcasses of the animals, the carcasses of the even buffaloes. So they are more useful, and that can be considered, that can be manufactured. How they manufacture, or manufacturers, they can just hone their skill actually on manufacturing these particular products. Even the even the patent. So when we are going for the patent, actually last one but not the least actually, patent is such a work actually where we consider that it should be inventable. Invention, that must be patentable subject matter. Maybe the process, maybe the machine, maybe the article or the manufacturer or the composition of the matters. So that patent is subject only and only when we can ask for the patent, that maybe the process, maybe the machine, maybe any product. So it's self-qualifying the novelty whether that particular process, that particular product, that particular machine or the article is having the novelty. Novelty means that is not known by any world. That is not known by at any corner. That should be new. Inventive step. Okay, India is very rich in the inventive step actually. Sorry. India is very rich. Our society is very rich of jugaad, which we usually say jugaad. Inventive step is a jugaad because the Paris Convention do not talk of the inventiveness, and even across the world, we are not yet able to come to the unanimity of the inventiveness, novelty, because it depends on the society, depends on the even the skill of the man to man. And the third one is the usefulness. So means until unless any patent or any process or any machine is not having the novelty, not having the inventiveness, not having the usefulness, we cannot go for the patent. So the patentability, patent that attract these qualifications, then only we can go for the patent. And like even the artificial intelligence. So if it is, of course, we are still in the want of the regulatory mechanism. What is the artificial intelligence? We do usually say the machine learning actually, and the machine learning or the artificial. By the term artificial, it is not the factual, it is not the fact actually. So artificially, we are training some machine. Means as desired, like the computer, like sometime when we preset our email ID, sometime if some mail is received by you, so automatically you said that whenever you receive, you send the acknowledgement received from the sender. Okay, so that we use just the artificially intelligence and the machine. How do you learn it? Nowadays it is evolving, and the evolution is with the time frame that more data, as well as the artificially you shave the data and you train the data, and artificial, like if you see Sophia is the one first artificial robot actually, and which has the even citizenship. So that robot says, somebody asks, of course, that beautifully the robot is well trained, a lot of data is fed there, and it has been doing wonderful actually, and a lot of interaction even it has done. So to that extent, okay, what is the difference between you and the human being? If somebody has I think access to the interaction of the artificial intelligence robot and the question, so you will understand, okay, the response of the artificial intelligence robot, the Sophia, that says, okay, that you are human being. You have the emotions and the whims and the emotions, which I do not have. So you have the emotion, we can understand the pain, we can empathize. Robot cannot empathize actually. Robot cannot empathize. It can work transparent. Recently, the High Court of Punjab and Haryana, they have started using the even artificial intelligence, deciding some judgments, and based on that, they could, of course, do something. But critically, and I can understand, sometime specifically in the civil case, we can use the artificial intelligence taking the decision, because we have the separate different situations, and by experience of the different situation, the artificial intelligence can run it. But specifically in the criminal cases, specifically in the family disputes, role of the artificial intelligence is little limited actually. At some time it may be very risky actually, and risky means they cannot empathize, they cannot take the decision sometime, because of the, we have to understand the sentiments of the person. We can think of the, yes, there are the possibility of the reformation, there are the possibility of reunion. We cannot simply break the relation because of some reason actually. No, that cannot be possible. So that way, it's a, we can be the good master if we explore it. And we are totally, if we remain totally dependent on or slave of the artificial intelligence or technology, sometime it will be the worst part actually. Usually, what we see that we totally dependent on the artificial, totally dependent on the technology actually, and that's the reason sometimes we are losing a lot actually. So therefore, the best part is the regulatory mechanism, because something wrong committed by the artificial intelligence, somebody must be fixed actually. Somebody must have the responsibility, like the programmer, like the sometime engineer, whoever is programmed actually. So that way, that artificial intelligence, even that is considered whether the artificial intelligence should be the part of the patent or part of the even the copyright. So even still not, because somewhere the program is protected under the copyright and the technology protected under the patent. So it is a combo of the patent and the copyright. So of course we don't have anything other than that. Everything is electronic and electronic based, and the technology, the programming. So therefore, yes, there is a need. How the midway, the solution we can bring out the midway solution. Even sometime we are discussing about the use of the artificial intelligence, even using in the educational institution. There have been the institution in the Bangalore actually, where the robots are teaching continuously for 6-7 hours to the students and responding to the students for the lecture, for the different varieties of the lectures, responding to the students. But only the thing is, if somebody is sleeping, somebody do not pose the question. So the artificial intelligence is not going to just snub the particular person, or sometimes just ask the person why you are sleeping, why you do not respond. If you are posing the question, you are seeking the query, yes, artificial intelligence is there to take care of you. Otherwise, it is not. So that way, at least the morally, as at least the personal touch, what we, as a teacher, can give to the student, artificial intelligence is no more. That can be the good mentor to the students. Even sometime, like the novelty, we do discuss actually the the invention will see to be novel if it is known, like the geographic, like the trademark, the traditional knowledge I discussed. Okay, if we have the traditional knowledge and we have digitally disseminated the traditional knowledge, protected the traditional knowledge, so one cannot simply get the invention with the help of the traditional knowledge. So that will be the wrong traditional knowledge actually. And the novelty, it should be new to all, new to all. It should not be that sometimes we ask the invention and discovery. Difference between the invention and the discovery. Discovery is sometimes we consider, okay, yes, it is existing, which is existing. You have to only discover it. And the invention is the new invention actually, novel, which is existing, but the new utility, new use of that particular invention, you need it. Like the inventive step, like the jugaad I was discussing, okay, it is beyond the repair actually, because beyond the workshop repair actually improvement. You cannot just gather the data, scrap it, and bring something new actually. Particularly section 3, it speaks of merely section 3D, a merely aggregation of the scrap and bringing one product, like sometime like sometime you go for the manufacturing of the chawanprash, taking all the dry fruits, crushing together and making the chawanprash. So that is not aggregation of the product and you create a chawanprash, no. But the difference is how you are bringing the different product and making its efficacy level higher than the particular product. So that way invention is there, that non-obviousness, which is not known to anybody. This is not known to anybody. Like when we discuss even usually a simple, it is not a complex, okay, invention should be very complex. Even the simple invention that can be patented. Simple invention can be patented. Simple invention, even the paper clip, even the sometime the clip. So that can be even got the patented. Means the purpose is sometime the utility, how you use, how you collect and creep the papers together. Somewhere the invention is that even the a very small thing, the pin, means the that you say the very paper pin with the very thin head, and the other pin is sometime the different, that is which is having the very U pin actually. U pin. Sometimes it even it does not harm the user actually. Paper pin sometimes harm the user, sometimes it get prick in the body. But sometimes the U pin, sometimes it does not prick. It will not harm the user actually. So how utility has been changed actually. So that can be the even simple, even the users non-obviousness is not there actually. Okay, that even the users or the expert in the particular domain is not aware of, okay, how to use it or how to do that. That can be there. Even the last but not the least, the usefulness of the industry application is usually as a student or as a researcher, we usually say that when we are going for the research, so at least it should be used for the society. Similarly, the patent utility purpose is, okay, at least when you are putting your labor, wasting your money, investing your money, wasting your time, using your time. So at least novelty is there, and that should be used to a particular society, at least to the sect of the society, particular class of the society, not to all, but at least to the particular society. So that should be there. Otherwise, if it is not used, it is not useful, no use of it. So you can just revoke the patent, can be revoked actually. So that can be there. So therefore, that says that it must possess the utility. No valid patent can be granted for the invention devoid of the utility of the industrial application. Merely industrial application, otherwise it will be no use. It will be of no use, and it will be just ending with it. So therefore, I conclude it, and I thank the management of Arya Kanya Mahavidyalaya giving me this opportunity of deliberation on the IPR. So with these words, I thank you. Now the house is open for the deliberation. And I hope all the participants, they will take all the perspective of the use of the artificial intelligence, the digital artificial intelligence, or the IPR or its protection, or otherwise the education perspective of the artificial intelligence. Thank you.
Thank you so much, sir.
Over to
Thank you so much, sir, for a very informative session. I am sure it is going to be fruitful for all of us. Thank you so much, sir. Now, I invite respected Ma'am Dr. Poonam Sivaj, co-convener of this seminar, for the vote of thanks of inaugural session.
Thank you, Rosie, ma'am. Am I audible?
Yes, ma'am.
So, very good morning to distinguished chief guest and keynote speaker of inaugural session, Dr. Naresh Kumar Vats, Dean, School of Law, Galgotias University, Noida, and former Dean Academics, Rajiv Gandhi National University of Law, Punjab, respected management members, respected principal ma'am, Dr. Aarti Trehan, and worthy participants. I, Dr. Poonam Sivaj, Associate Professor, Department of Physics, Arya Kanya Mahavidyalaya, IQAC Coordinator and co-convener of this seminar, on behalf of Research and Innovation Cell, Arya Kanya Mahavidyalaya, extend very sincere and hearty thanks to Naresh Kumar Vats, who has enlightened us on the topic of the webinar, that is Innovative Trends of IPR in the Digital Era, in an excellent way. Sir, you have explained very well copyright, patents, and trademark interface, traditional knowledge, and digitization. Sir has raised a very important issue that a property well known to traditional Indian culture, like use of turmeric, basmati rice, and the patent has been taken by some other countries. So it is the high time for the digitization of traditional Indian knowledge. Sir has also explained copyright, trademark, trade secrets. These can be for any sort of work like artistic manifestations, literary work, textile works, pottery, ceramics, paintings, stone carvings, cinematographic works, etc. So in nutshell, we can say that we have huge resources, knowledge, works, but not on the records. So such kind of discussions will surely help in digitization of Indian traditional knowledge, sir. So, sir, we are highly grateful to you for accepting our invitation. You have shared your precious knowledge and time with us, giving wonderful, informative, interacting, valuable, and knowledgeable session. We feel really fortunate to be with you, sir. Once again, thanks a lot, sir. Thank you very much, sir.
Thank you, ma'am. Thank you. Swati ma'am, thank you. Guru ma'am, thank you.
Thank you, sir.
Thank you, sir. Thank you so much.
Thank you.
बहुत बढ़िया था सर, बहुत इंटरेस्टिंग, very interesting.
Thank you.
Thank you so much, sir. Thank you, ma'am. It's time for a tea break for 15 minutes. We request all of you to kindly assemble here before 12 noon. Thank you all. Yes. May I start, ma'am?
Yes, Rosie ma'am, start.
Thank you so much, ma'am. Once again, welcome you all in this national seminar. I extremely welcome today's resource person, respected ma'am, Ms. Rima Sani, Head Innovation Technology Transfer Office, IIT Delhi. And also heartily welcome resource person, respected ma'am, Mrs. Parvati Agarwal ji. Before inviting today's resource person for session 1, I introduce such a dynamic personality among us, Ms. Rima Sani ji. Ms. Rima Sani is currently heading Innovation Technology Transfer Office, ITTO, a foundation for innovation and technology transfer, Indian Institute of Technology, Delhi. She holds Master in Life Sciences along with a diploma in Intellectual Property Rights from National Law University, Bangalore. She is a patent agent, trademark agent, and has been awarded with the RTTP status. She is an awardee of the Women Scientists C Scholarship under Kiran IPR by Department of Science and Technology, Government of India. She has been recognized as an innovation ambassador by MHRD, Government of India. Ms. Sani has a breadth of experience of 14 years, of which she has dedicated more than 10 years in the domain of intellectual property and since is actively involved in formulating intellectual property and technology transfer strategy for the client's invention and advising many startups and individuals on securing, protecting, enforcing IP rights and helping them in commercialization of their technologies. Her journey is featured under Success Stories from Women Scientists Scheme, Women in Science and Engineering, Vice Kiran IPR in a book published by Department of Science and Technology, Government of India. She has recently received the scholarship under the Danida Fellowship Center Scholarship Program, Danish Ministry of Foreign Affairs for the course fostering innovation and commercialization of intellectual property. Ma'am, we are honored to have you as our resource person at our event. Now, I invite respected ma'am Rima Saniji to share some knowledge on IP strategies in digital age. Please, ma'am.
Thank you, Ms. Gar, for your kind words.
Thank you so much.
Yeah, I'm just sharing my slides. Please confirm if my slides are visible to everyone. Ms. Gar, can you confirm?
No, ma'am, not visible.
Okay. Let me share it again. I guess now it is visible.
Yes, ma'am, it is visible.
Yeah, a very good afternoon to everyone. Hope everyone has enjoyed their tea. So today I'm talking about IP strategies in digital age or digital era. Nowadays, IP rights, I would say it has become very vulnerable. Why? Because earlier faculty, research scholars, or any innovator used to present about their work in any conference or at any tech showcase. But due to digital era, now the copying is very easy for everyone. So it has become very crucial to protect our IP rights at an early stage. So let's discuss about little bit about what is IP, IPR, and I know the previous session was also on IP, but I will keep my discussion very simple so that anyone who is not able to understand the complexity of IPR will able to understand that. So what is IP? Intellectual property is just like other property, but it is creation of our mind. With our mind, it is ability to create something. If we are writing a book, it is also our intellectual property. If we are drawing something, it is also a type of intellectual property. And likewise, if we are thinking out of box and giving solutions to unmet needs in our society, and this is also the type of intellectual property. So anything which we are creating through our mind and it has utility is called intellectual property. And intellectual property rights, these are called safety belt for your ideas, because whenever we are creating something, it all starts with one idea. Like if you are sitting in your lab and you have some idea, okay, I can invent this thing. So this is your IP, but you can only protect this if you have, the solution for the same. So IP, it can be protected through various rights, copyright, patents, trademark. And India, if you want to protect your intellectual property, then you had to go through a channel. For example, in India, if you want to protect your inventions, your trademarks, your industrial design, then you have to go to Indian Patent Office. And if you want to protect your copyright, it can be any literary work or any software, then you have to contact Copyright Office. Depending upon the type of IP, there are different acts which are available. Trademark Act 1999, Patent Act 1970, and Copyright 1957. And periodically, to align with the ecosystem, there are amendments in these acts too. So there are different type of intellectual property rights. Patent, in case you have innovation, like you have invented something, it can be any product or process. You can protect it through filing patent application. And you have this, you can see the logo of your college and the logo of McDonald's, the famous logo. So you can register it under trademarks. Likewise, if we talk about look and feel of objects, then you can file industrial design application for the same. And copyright, because you are from academic institution, you know the importance of copyright, how important it is. So if you are writing a book, then you can protect it under copyright law. And trade secret is like there's no need to file any formal application. Trade secret is like it can be any formula, anything, and it remains with the owner of that company or the leadership. Nature of intellectual property, right? Intellectual property, it is basically creation of your mind. Anything which you are creating with the help of your mind is your IP. Like other property like house, cars, it is intangible. It is unlike them. It is intangible property. It is not, you can't touch it. And IP rights are exclusive rights in nature. For example, if you are filing patent application and your patent will be granted, then you will have monopoly over your work in the market. So you will have exclusive rights on your innovation and you can stop others from copying your innovation. That's why it is also called negative rights in nature. IP rights are called territorial in nature. Why? Suppose you have filed patent application in India, then you can enjoy IP rights, your rights over your innovation in India itself. But if someone is copying your idea in US, you can't stop that person, because for that, if you want to protect it in US as well, then you have to file patent application in US itself as per USPTO, as per their laws.
Sorry to interrupt you, ma'am.
Yes, yes,
Your
please.
slides are not moving. Presentation is static actually. The slides is not moving.
Okay, now is it moving?
No, ma'am.
Okay, what's happening? I'm resharing my slides. Okay, I'm not keeping.
स्लाइड शो कर दो रीमा मैम.
मैम वो पहले स्लाइड शो था, इसीलिए शायद वो मूव नहीं कर रहा था. गूगल मीट में थोड़ा इशू है. अभी मूव कर रहा है?
Currently,
Yes.
ma'am, currently
हो रहा है.
slides पर 3, slide number
हाँ,
2 is
ये
visible.
गूगल मीट में थोड़ा इशू रहता है इसमें स्लाइड मूविंग का. तो मैं इसको जूम करके ही प्रेजेंट करती हूँ स्लाइड मोड में, अगर नहीं मूव हो रहा तो.
It's fine. It's fine now. Currently,
fine
you're
now?
at. Fine. Yeah, it's fine now.
Okay. So there are different types of IP, and all the IP rights are time bound in nature. For example, patents are granted for 20 years from first filing, and after 20 years, they are free to use by public. Because IP rights are given by Government of India, that's why these rights are legally enforceable as well. Suppose if anyone is copying your idea, you can take legal action against that person or company. Why IP rights are important? Why it is important to file patent application, trademark application? Is it important or not? It is very, very important. And if you are planning to launch your business, or if you want to earn revenue, then it is very important to protect your IP. The first of all, it will help authors and creators to get recognition for their work. If you have worked upon any book and you will file copyright, then it is like you will get copyright certificate from the Copyright Office. It will be as a recognition for your work as well. And also it will incentivizes inventors, creators for their work as well. Suppose if you don't want to work on your innovation or any book, then you can give license to any company, and in return of that you will get revenue in form of uh, upfront payment or royalty. So it is very beneficial for you. And also IPR is very important because it encourages R&D at any organization. And also you give new solutions, innovative solution to our society, which help them in uplifting of their lifestyle as well. For example, life-saving drugs as well. So there is one thing, there are few innovation in which innovator hardly file any patent application. I can give one example which is very important: the COVID vaccine. Our government, they didn't file any patent application for the same. Why? Because after filing patent application, there will be monopoly in the market. But it was a life-saving drug at that time, and our government wanted to avail it to all the country people and other countries as well. So no patent application was filed for the same. And also intellectual property rights, it facilitates technology transfer in form of foreign direct investment, joint ventures, and licensing. So you should have one strategy for your innovations, and you can earn a lot of revenue out of it. Benefits, as I discussed earlier, you are providing creative solution to the society, and also IPR facilitate better collaboration with the industry as well. Nowadays, our government also focus on industry and academia collaboration, which is very important because academia has that skill set and those resources so that they can work on innovative solution, and they can meet the unmet need of industry. And industry has revenue. They can give money to the academicians so that they can work on the solution which they want. And also industry has those resources which can help academia, which they can handhold academicians and take their technology from lab to the market. And also, if your academic institution is working on any solution, and there is commercialization of that innovation as well. So it helps to create brand value for your academic institution as well. For example, in IIT's ranking, IIT Kanpur is at rank 1. Why? Because the commercialization of their innovation is, the rate of commercialization is very high at IIT Kanpur. And also, if you are protecting your IP, you are preventing research duplication as well. Otherwise, anyone can copy your idea, and you will have no any evidence for the same. And also, you are helping to foster innovation ecosystem around you. And career opportunities, suppose if you are very passionate about your work, you can form your startups. And if any faculty member or researcher is forming startup, the keyword spin-off is used for the same. And also, if you are forming your startups, you will need some people with different skill set to run a business. So indirectly, you are creating employment for others as well. And this is the best way for revenue generation as well. Either you can take your technology directly to market by forming a startup, or you can license it out to the industry. So both way you will earn revenue out of it, and that revenue can be used further for R&D purpose, and also can be shared amongst the innovators and academic institutions. What are the drawbacks of not protecting your IP? Anyone can copy your idea and you will have no any evidence that this belongs to you. And of course, you can't take legal action against that person because in IPR, if you have that IP right in your name, then you can take legal action against that person. So, suppose you are discussing about your idea with industry and you have not signed any non-disclosure agreement with the industry. And after that, industry has copied your idea. And because industry has enough resources to take it to the market, so indirectly you are creating competition for yourself. So be careful if you are ready with your unique work, like either it can be any innovation, it can be any book, it can be any lyrics or music. Immediately you should file IPR and protect them. The first and the most important is patent. What are patents? Patents are basically exclusive rights which are given to the innovator or the applicant basically who owns the rights. They will have monopoly in the market. No one other from that person, patentee, can use your idea. And patents are granted for product as well as for the process in India. And the tenure for patent is 20 years from first filing. As discussed earlier, patent rights are territorial in nature. If you want to protect in other countries and if you want to enjoy the patentee rights in other countries, then you have to file patent applications in other countries as well. So it depends upon the strategy. If you think you want to do your business in US or suppose in Sri Lanka, then you should go for filing patent application in other countries. Otherwise, there is no point of filing in other countries because it is very expensive. So, because you are stopping others from copying your idea, that's why patent rights are called negative rights in nature. And likewise, other property like your house property, you can also sold, license, and mortgage your patent. Rights of a patentee. If patent has been granted to you, then you have right to manufacture and use your innovation. You have right to sell the patented innovation, and you can also prevent others from importing the patented innovation. Reasons for filing patent application. The first of all, it is incentive to innovator. Suppose you are working on any innovation and that innovation you have filed patent application and you got grant for your innovation, then nowadays as per new amendment in patent rule, you can get the certificate where your name can be cited on the patent certificate as an inventor. Earlier only the applicant name was there, so you can add the same in your CV as well. And the second is it foster R&D culture at your organization. For example, in chemistry lab, you have invented something and you got patent for the same. And you can, the students, researcher in lab, in physics lab can inspired by your work and they can also, repeat that thing. So this way you are fostering R&D culture at your organization. And from your innovative solution, you are bringing technology to the market. But the most important thing is that your work should be what? It should be novel. It should not be in the public domain. And it should have industrial applicability. Then you can take it to the market. In fact, industry may hold interest in your technology if you are actually giving unique solution to the unmet needs. And also it promotes tech transfer and commercial exploitation of the technology. In previous section, you have learned about patentability criteria. It's just recap of the same. So while filing patent application, and suppose I'm the examiner and I'm scrutinizing your patent application, So I will check if your patent application is qualifying for these four parameters. The first one is novel and utmost importance. If your technology is unique, it should not lie in public domain. It is said that even the single paper worldwide can kill the novelty of your innovation. So it should not be anywhere, not published or not in any form. The second is non-obviousness or inventive strength. So your innovation should not be obvious to the person who are skilled in that art, and it should have technical edge from already existing technology. For example, even the same patent can be granted for the similar kind of innovations as well. I can give you one example. For example, in COVID era, there was first diagnostic kit, and we used to give sample, and within 1 week we used to get the result. But then there was fast track kit, in which within seconds, even at home, you can test your sample and get the result. So both the innovations are solving the same problem. But the second thing is that it is fast track kit, and you can easily use that without any additional help. So there must be some inventive step. That's why the time has reduced. So your innovation should have the inventive step, and the third is it should be it should have industrial application. If you can not use it for the for commercial purpose, then there's no need to file patent application. The fourth one is very important. As per Indian Patent Act 1970, there are two sections, Section 3 and Section 4. If your innovation lie under Section 3 and Section 4 of Indian Patent Act, then you cannot file patent application for the same, because as per Indian Patent Act, those are non-patentable subject matter. So types of patent application, there are different type of patent applications. Ordinary patent application, the simple patent application in which you are not claiming any priority, you are simply filing patent application with the Indian Patent Office and comply with all the rules and regulation of as per Indian Patent Act 1970. Now you have filed patent application in India. It can be provisional patent application or complete. But after that, you worked on your innovation, and you contacted some professional and then checked the market potential of innovation in other countries. Then that professional suggested you can file patent application in Malaysia or in Sri Lanka, because there is market potential of your innovation in those countries as per their ecosystem or environment. There is need of your innovation. Then there are 2 or 3 ways by which you can file patent application in those countries. The one is you can directly file. The second is you can go through Paris Convention, because in Paris Convention, from the first filing within 12 months, you can file it in other countries as well. The third is PCT route. There is a benefit of filing through PCT. The first is in one language, you can file in other countries as well. There are few countries like Japan and where you have to file translation of your application as well. But benefit is that after filing PCT, you will get relaxation of time. Within 30 to 31 months, you can enter into national phase in other countries. Until that time window, you can further work upon your technology and will see, okay, is it fine? You should file in Sri Lanka or Malaysia, or you can file in additional countries as well, or you can delete 1 or 2 countries as well. So it has a benefit. I have few example, like how one can be billionaire by filing patent application. So there was researcher at University of Florida. They started working on one problem: why the school's football players were being affected by the heat. And they invented a new drink and named it as Gatorade. And then they sold this formula to a company, Stockley Vancam, in 1967. And at that time, company agreed to pay them upfront payment of $25,000, and with that small bonus or 5% royalty on every gallon sold. So at that time, they transferred this technology to one company. And after that, that company was acquired by Quaker Oats and Company. You must aware about acquisitions and mergers. So this company was acquired by another company, and the company was now selling its product in 45 countries. And you won't believe, this University of Florida is earning a lot of revenue from this technology transfer till date. So this is very good case study. So this is for academic institution. If you are working on any technology, sometimes if you are solving the unmet need, like no one has already worked upon that technology, and also if it has commercial utility, you can earn a lot of revenue out of it. And there is one example from IIT Delhi as well. There is one smart cane for the blind people, and it is, you know, this technology was sold in 1 rupee only. And there's very surprising thing that IIT Delhi is earning highest royalty from this smart cane technology till date, because that technology was sold to NGO, and this was for social cause. That's why the upfront payment was kept very low. But now the commercialization, if I talk about the commercialization of the technology, so royalty amount is calculated on the benefit which the company is earning, and the company has to pay that much royalty to that academic institution. So there is a failure story as well. The innovator who did get rich. So in 1979, Xerox, they decided not to patent its GUI, graphical user interface. And later on, this technology formed the basis of Apple's Macintosh and Microsoft Windows personal computer operating system. So if we calculate the revenue lost for Xerox, so they lost around USD $500 in million during the lifetime of the patents, because patent is granted for 20 years. So we calculate the royalty amount as per the patent life. Now the second type of IP is trademark. Trademark is one's identity in the market. For example, when Starbucks and McDonald's, likewise the Microsoft, they all thought of launching their business in different countries. The first, they protected their IP. So they protected their trademark as well. So TM is used for the trademark which you have filed, and R is for registered trademark. If you got the registration on your trademark, then you will get certificate for your trademark registration. Then you can use R in circle. So basically, if I talk about the brand value, trademark helps to create brand value for your company as well, because now we can relate, okay, Xerox and this thing, toothpaste. If I talk about toothpaste, then you can relate it to this Pepsodent or anything, Dabur, Manjan. So these all are trademarks, and you can, and also the Apple and Samsung. So if I talk about the Apple, they have created their worth from, they have created their brand value with their trademarks. And now you can identify the quality which Apple is promising to its customer. So the term of a trademark is 10 years, but you can renew it infinite time. And also it is recommended to protect your trademark before launching your business. And nowadays, innovators are very smart because we have so many startups incubated at IIT Delhi. And whenever they start working on any idea, they scout for IP at the early stage, not only patent, because everyone is thinking that patent is important, not other IP. This is wrong. Nowadays, if you are pitching in front of any investor, first they will ask you, have you filed IP? Have you created IP portfolio for your technology? And what all IP you have filed? So it is very important to scout for other IPs in your technologies as well. If you have startup and you are running a business, you can give unique name to your product or process, and you can file trademark application for the same. And nowadays, innovators are hiring product designers who can help them in enhancing look and feel of their product so that they can file industrial design application. So there is a myth only the patent can be transferable. Even the trademarks, copyrights, and industrial design can also be transferred to any industry or anyone who is working in this ecosystem. So other IPs are all equally important. If we talk about the different type of IPR, they all are equally important. So basically, trademarks they are any sign which individualize the goods of a given enterprise and distinguish it from its competitors. Because if you go to the market, you know what is you can easily differentiate between Apple and Samsung. You can easily distinguish between Starbucks, McDonald's. So these are the brand value of the companies. What can be trademark? The word mark can be protected, logo can be protected, even the shape and the packaging marks can be protected. Colored mark can also be protected. And combination of word mark and logo can also be protected. And sounds and spell marks are also trademarked. The next type of IP is copyright. So in today's digital era, copyright plays a crucial role in this ecosystem. Why? Because nowadays, which I found, innovators are more into app-based technology. They are not into deep tech. So it is very important to first, protect them because they can be copied very easily. And also there are some provision by which software can also be protected under patent act, but it is still contentious matter, but it depends upon the drafting skill of patent agent so that they can get patent over their software. So copyright is exclusive rights, or I would say it is bundle of rights which are given to the creator of the original work. The one thing is very important, it is given only to the original, creator of original वर्क कॉपीड आइडिया पे कॉपीराइट नहीं मिलता. कॉपीराइट का मतलब ही बोला जाता है डू नॉट कॉपी. So copyright protection, it does not depend upon the registration. Why? As and when, if you have written something, you can email to yourself and then you will create evidence, okay, this work belongs to me. So it is not mandatory to file copyright application, but as a professional, I will always recommend you to file copyright application. Why? Because if in future anyone is copying your idea, you can take legal action against that person. And the most important thing about copyright is that copyright law protects ideas expressed in a tangible form, not idea per se. I can show you. So I have one idea of painting in my mind. Okay, I can do this and do this, but I cannot protect it through copyright law until or unless I express my idea on canvas. Then I can file copyright application for the same. And the very important thing is that If you are working in any company and you have signed employment agreement, then the work during my employment which will be created, I will be honored as author, not the owner of the copyright. Because in my employment agreement, it was mentioned all the work which will be created by me during my tenure of employment, all the copyright will belong to my company. For example, you can check at the bottom of my slides, I have mentioned copyright ITTO. I'm the author of these slides, but the copyright owner is my organization, Innovation Technology Transfer Office. So under copyright, literary work can be protected, and it also covers software as well, musical work, artistic work, and sound recording. These all are covered under copyrightable matter. And the rights which are under copyright law are rights to publicly display your work, right to make derivative work as well. That's why I mentioned first line that copyright is given to the creator of original work. If you are someone is copying it and making the derivative work, then no copyright will be given to that person. And under copyright law, you will get right of adaptation, right to distribute, and right to reproduce your work as well. This is one of the types of IPR, industrial design, where IP rights are given for the look and feel of the article. As I mentioned earlier, nowadays, if you are working on any innovation and it is a product, then you can hire product designer as well, who can work on your innovation and it enhance the look and feel of your product. Because nowadays, if I'm buying any sofa set for my home, because it's, everyone is hiring interior designer for their home, and there are fancy lights as well. The charges, if I talk about the simple bulb or tube or the fancy lights, you can see the difference of their cost, but still I'll go for fancy light because it is looking good at my home. So people are like, they can spend 10 times more money as compared to the simple thing because of their look and feel. So basically, the IP industrial design focus on the aesthetic feature of an article, and also it enhances the features which enhances visual appeal of that article. It can be registered for shape, configuration, surface pattern, color, line, combination, anything, but it should be applied to article. If you have drawn something on any paper and you are thinking you can file industrial design application for the same, no, never. Until or unless you have applied that design to one article. Same goes for the apparel as well. Fab India, like W, they can file industrial design for their clothes as well. And the protection tenure for copyright is 10 years from the date of registration, and it can be further extendable as well. It can be filed for any device or the apparatus or the component of one device as well. Now come to the significance of IP searches. Why it is important to first do the prior art search in case of patents and trademark search in case of trademark before filing it. So novelty searches or prior art searches, it plays crucial role while filing any IP, because patent application filing is, very expensive. And if you are doing it without any IP due diligence, any patentability assessment, then you may lose your patent application, and also lots of money you will also lose. So before filing patent application, it is always advisable. We usually advise to our clients, okay, first do the IP due diligence, then file. Otherwise, it is important to avoid reinventing of the wheel as well. Otherwise, your application will be opposed or objected by Indian Patent Office. and also unnecessary to avoid unnecessary expenses or time on filing patent application. Now comes to the strategies to protect innovation. It is very crucial if you are working on any innovation, then first scout for IP at an early stage of research and for the computer science department as well, because you are well aware that software can be copied very easily. They are very vulnerable. Then as and when you have created something, it should be original. You can always go for filing copyright application. And if you are adding some hardware with your unique software, and it is not mandatory your hardware should be novel, then you can file patent application for the same as well. So at the early stage, you should scout for IP in your work, and then you have to decide your IP rights need to be formally registered or not. For example, copyright, there is no need to file copyright application, but it is always advised to file copyright application, because if anyone is copying, then you can't take any action against them. It arises automatically as and when you create that. The second strategy is prioritize which IP to protect. See, there are different type of IPs, but if I talk about patent application and industrial industrial design application, if we are filing patent application and we found that there is unique and aesthetically nice product, then we always advise our client innovator, please file industrial design in parallel with patent application, because then the novelty factor comes in picture. So they should be filed immediately as and when created. And also there are trademarks, and you can anytime delay it, and you can file trademark application if you are using it, but keep evidence, bills or anything, you can delay filing trademark or copyright, and after that you can file the same. And you should always think, okay, this IP is very important and it will favor my business plan as well. So first prioritize as well, because there is funding crunch as well. If you have created a startup, then you can have different kind of schemes as well, and you can file for rebate as well. There are different categories at different stages. There are many government and non-government organizations who are giving funding to the startups. Not only to the startup, even AICTE's Yukti scheme is for individual innovator as well. There can be student from any college who can apply, and up to 10 lakhs they are giving funding. And but their criteria is that they have to form startup and they have to be associated with any incubator, so that there will be commitment from the student. Okay, they can take it to the further. And also for the patent application and other type of IP, there are different schemes under which they can attract, they can have funds for filing that. So there are different strategy by which you can prioritize which to file first and which you can delay. Formulation of IP strategy. So it is also very important. First, if you are ready with your innovation, first you should have one SOP in place, which is standard operating procedure. Like if you are ready with your innovation, whom should you contact? Like if I talk about the Pioneer Institution, they have their IP and TT cells in place. In IIT Delhi, they have their IP policy where everything is well defined, like whom you have to contact and what are the forms you have to fill, how will you qualify for filing patent application, and after filing as well, if there is any technology transfer, who will be the owner, who will be the authorized person who will take it forward, and also the revenue which will be generated out of this technology transfer, how it will be distributed amongst different stakeholders. So everything is well defined, revenue sharing model and everything. Likewise, other academic institutions should have this kind of SOPs so that innovators is aware, okay, now I'm ready. Let's discuss with the professional how to go further. There is set format which is called invention disclosure, which will be filled by innovator, and the professional will evaluate the invention if it qualify for filing patent application or not, and they will check the patentability of that innovation. If they will get uh, go ahead, then they will file patent application in India. And also they will check for the market potential of that innovation in other countries as well. And depending upon the market potential, they will file patent application in other countries as well. And in parallel to that, they will scout for other types of IP in that innovation as well. As stated earlier, like if you are giving unique name to your product or process, you can file trademark application for the same. If you are working on look and feel of the product, then you can file industrial design for the same. If there is involvement of any software, you can file copyright application for the same. Likewise, you can you can create IP portfolio for your innovation. And nowadays, it is very crucial to have IP portfolio for the effective commercialization, because when you are going for, pitching in front of investor, or you are filing application for any funding scheme, then there will be mandatory question of IP which you already have filed, and what is the status of that IP, and what what are your aspiration plan if you talk about your technology. So these are the mandatory question, and also they will talk about the business plan, and if you have filed IP, if they align with your business plan or not, how will they helpful for your project. So this is all about the strategies of IPR in today's digital era. So if you have, because I guess we are running short with the time. So let's discuss, and if you have any query, you can please discuss with me.
Delegates, if any query, please ask.
Good afternoon, ma'am. Ma'am, I'm Dr. Aarti Singh from Guru Nanak Girls College, Yamunanagar. Ma'am, I filed 2 patents in 2015 and 2014, and both my patents got published in Indian Journal of Patents. Then I thought that patent was granted to me as the work was published in the journal, but later I realized that some process is missing, as I have not received certificate for the patent. What needs to be done further?
Ma'am, there are subsequent steps as well, because if you have filed complete patent application, the first is within 18 months, it will be published. And after that, you have to file request for examination. Have you filed request for examination? Because I don't think so. Are you filing on your own, or have you taken assistant for any professional or patent agent?
Yeah, I took help from a lawyer who was actually, earlier I was in Maharishi Markandeeshwar University, so it was IPR attorney of the university who helped us file the patent. and we paid for that also.
Yes, then it was his duty to maintain the deadline. I guess you still have time. Within 48 months, you can file. Okay, it was in 2015.
Yeah, it was in 2015.
Okay, oh
Uh,
my God. So you should talk to him why he was not able to maintain the deadline, because within 48 months you have to file request for examination. Then the IPO would have examined your application.
okay, and now I have to restart the process again if I wish
Yes,
to
yes,
get the patent.
yes. But the thing is that you can't file the same application because it was published by IPO.
Okay.
It means it is in public domain. Then you have to do something different kind of work. Then you can file patent application for the same. I think you should talk to the attorney. How can one, miss that deadline?
Yeah, actually, I was dependent on him only. I was more towards inclined towards research, and I was not much aware about
I
the
can
patent
understand. I can
process.
understand.
Um, thank you. I will talk to him and we'll see what I can do into that.
Yeah. Thank you.
Okay, but ma'am, otherwise also can I take the benefit of that publication in the Indian Journal of Patents, as both were my research work which got published.
You can write in your CV, okay, to patent application. You can't use the word patent because it has not granted. You can use my 2 patent applications have been published by Indian Patent Office. Yeah.
Thank you, ma'am.
Thank you.
Any other question? Delegates? Thank you so much, ma'am. We are truly grateful for the time, effort, and expertise you have shared with us, enriching our understanding, inspiring us. Thank you so much, ma'am. Now, thank you, ma'am. Now it's
Poonam ma'am is saying something. Ma'am, you are on mute.
Anji, Anji, Anji.
She's on mute.
Thank you, Rima.
Thank you.
How are you?
I'm good. Nice to see you, ma'am.
Nice talk. Nice talk. Thank you.
Thank you. Bye.
Now, it's time to introduce our session to resource person. We are privileged of having a esteemed individual with us. Today, respected Ma'am Pragati Agarwal ji, Project Manager, Innovation Technology Transfer Office, IIT Delhi. Welcome, ma'am. Ms. Pragati Agarwal is a registered Indian patent agent with the Indian Patent Office, Government of India, and has been awarded with the international status of Registered Technology Transfer Professional by Alliance of Tech Transfer Professional. She is currently working as a project manager with the Innovation Technology Transfer Office with key focus on intellectual property management, technology transfer, and capacity building. She started as an intern at Innovation Protection Unit of CSIR. She is actively contributing towards innovation ecosystem and Atmanirbhar Bharat. As a part of the team, she performs patentability assessments, patent evaluation, FTO, due diligence, technology analysis, licensing, technology transfer, IP and TT strategy formulation, and capacity building programs. She helps protect, manage, and translate innovation in various domains of sciences. Academically, she is a biochemist and DST Inspire Fellowship awardee. Ma'am, your unique perspective and expertise would be a valuable addition to our seminar. Now, I request respected Ma'am Pragati Agarwal ji for sharing her valuable perspective on digital licensing models. Please, ma'am.
Thank you so much, ma'am, for the introduction. A very good afternoon to one and all present here. So I'll be quickly sharing my slide. It would be great if you can confirm. Is it visible?
Yes, ma'am.
Are the slides moving?
Moving, ma'am.
Is it moving?
Yes, ma'am.
Yes, ma'am.
All is fine.
Okay. Thank you so much, ma'am. So in the previous lecture by my colleague Miss Sani, so she told us about the IP and its different forms, and then how IP can help us generate revenue to bring back that money which has been invested in any creating an invention. So how we can bring it back, and then the same money can be reused or reinvested either in the further development of the same invention or in the different projects. So I'll be quickly recapping the thing. So, as you all know now that there are different forms of IP, the patents, copyright, trademark, trade secret, designs. So, how they help you as an inventor or you as an applicant to build further. So, you can generate revenue. You can create a continuous revenue stream out of the generated IP if you protect it well in time. Other than that, it helps you build your brand value. It helps you give a competitive edge in today's era. So for example, the IP rights are exclusive to you. Like nobody else can work on your inventions, the inventions that have been created and applied and protected by you. Nobody can use it unless until you give it a consent. So these exclusive rights brings you the monopoly, brings you the competitive edge in case you are commercializing them in the market. So the next step, once you have filed an IP application, or once you have created an invention, what next? The next step would be the application filing, and then you don't have to wait for getting it a grant. In case it is an intellectual property, in case it is a invention, in case it is a product or a process that has been developed, and you have timely filed an application over it, so there is no need to wait till the grant of an IP. You can start looking for commercialization. You can start looking for licensing opportunities the day you have filed an application over it. And the next step would be the tech transfer. So the tech, how, like, what is the simplest form of the tech transfer that can be explained is any technology, not necessarily be any product or process, any technology, even the trademarks or the copyrights, any technology which are created by an inventor or an organization, and the process of transferring them to other organization. The other organization could be a group of people, it could be an industry, it could be a startup, it could be an MSME or an SME, it could be any organization. So that transfer of technology from the innovator to other organization, and again the innovator could be any institute, any loan innovators, even the startups as well. So nowadays there are many startups that are working on the similar concepts. So what they can do, for example, I as a startup or I as an individual, I'm working, like I have created something, I have developed a product, and some other startup wishes to develop it further. So now what they can do, like we both can do, I can transfer my product till stage A to them, and then they can further work upon it and take it to the next level. So even this process would be termed as the tech transfer, because I might not have those resources, or I might not have those skills to develop it further, or maybe I don't want to develop it further, my purpose has been reached. So I can give it to somebody else, I can give it to some other brother or sister organizations, or any organization that wishes to adopt it, and then they can further build upon it, they can build upon it, they can commercialize it and bring it to the market. So this is the tech transfer. In simplest form, this is the tech transfer. Any transfer of a technology from the developer to the people or to the organizations who are willing to carry it forward. Now coming on to what gets transferred. So apart from IP, apart from intellectual property rights, even if there are certain technical informations or even the know-how, or even the materials, technical materials. If you look at the for example, if I as an individual, I have developed some formulations, some drug formulations, or maybe some cosmetic formulations. So now I need to get them tested through the third party, right? So even that's a case of a tech transfer, because I am transferring my technology to them for a certain specific reason. So the reason would be mentioned in the agreements that would be doing, but this is also a form of a tech transfer. So in such cases, even the technical materials or the equipments, even if some laboratory is letting me handle their equipment, so they are in a sense they are in a sense licensing it out to me for a certain specific period of time for a certain specific reason, beyond which I know, I hold no responsibility, or I hold no I hold no operational rights over them upon beyond reaching my purpose. So any technical information, any intellectual property, be it a patent or a trademark or a copyright or a know-how, any performance skills, like how you are performing certain practical or certain process, even that can be transferred. So not necessarily an IP should be there. So this is actually a very misnomer or a misleading statement. Like people tell you that you can transfer a technology only after getting IP rights over it. So first, you don't necessarily need an IP to get it transferred, even if there is a technical information, even if there is a know-how or any such expertise skills, you can still transfer them. And in case of IP, it is known as IP translation. And when we talk about the other aspects, it will be termed as tech transfers. So the next step would be like, how does the actual commercialization takes place? So tech transfer is the first means. Second is the spin-off creation. So this has also been mentioned by my colleague. So when we talk about the simplest tech transfer, so tech transfer is something I have developed a tech, it to somebody else. Now I have no longer any rights over. They can use it, they can manufacture it, they can commercialize. Spin-off is closely associated when with the universities. So what happens as a faculty or as a student, up some, what you can do next, you discuss internally and you can create a startup out of it over that concept that you have worked upon, or that technology that you have worked upon. So that would be a spin-off creation. In like every university has its own regulations, own norms, rules, a set of rules, like how such spin-offs or how such startup formation would occur. So generally the most probable and thumb rule is that a single, like one faculty needs to be there as an like advisor or a consultant to that spin-off. So in such cases, students generally come out with such inventions or such technologies, they create a spin-off out of it with their faculty or their PI as the advisor or consultant to them, and then they can start it off, they can further build upon it, they can further research upon it. And in such cases, since the technology was developed at the university level or at the academic level, so that spin-off needs to get a license of the technology from the university. Like the same example was given by my colleague Rima about the smart cane. So in that case, the technology was being licensed out to that organization, and they on it further. So IIT Delhi took the very very less. It was a bare minimum kind of a thing, just a sudden thing. Rupee 1, they licensed it out in Rupee 1, but now they are doing wonders in terms of royalty. So now let's understand what could be the different stakeholders. Like when we talk about technology transfers, like is it a one-person process or it is a two-person process? Like how it is actually poised when we talk about the tech transfer and the whole ecosystem. So the very important person in this whole ecosystem is the tech developer, who has developed the tech. Because if tech wasn't there, like the would not have been taken place. So the very important part of the stakeholders is the technology. Now, if your technology has a potential, by potential I just not mean like if it is working under in the lab level. If it should have potential to work on the bigger scales as well, you should validate it. You should run those tests over it, so that you can be sure enough that yes, my technology is capable of at least doing fine beyond lab level or beyond the lab stage. If in case it is TRLs. By TRL I mean technology readiness levels. So there are different technology readiness as per the standard meters. So when we talk about lab scale technology, so lab scale technologies generally bear a very low TRL levels, and in such a case, industry people or the potential buyers, they they opt less for such technologies, because there comes a maximum risk of how that technology would perform beyond lab level. So it would be great if a person who has developed the technology can validate it, at least if not on the larger scale, if not on the industry scale, then at least beyond lab level. So that would assure the seeker or the buyer to at least give it a thought. And if an industry is giving it a thought, they will definitely consider it for some staged. If not, if like for maybe they can opt it for a certain minimum number of years. They can try it out, they can further build upon it, then they can maybe if the product goes well, if the readiness goes well, they can further exercise it in the commercial in the market. So it completely depends like how well the technology performs. If we talk like in terms of its performance at the lab level, beyond the lab level, and how far it has solved the unmet needs of what was not solved by the products or the technologies that are existing in the market. So how this technology is meeting those unmet needs, is bridging that gap which was not filled by the existing products or technologies. Now this specific route is generally taken care by the technology supporters, that is tech transfer offices. So usually every university has like in today's time, most of the universities have established their own IT cells and TT cells, which takes care of such requirements. So these people, they know better. Of course, the developer knows about its technology, but the TTOs find out how how efficient that technology is, or how valuable that technology is, so that they can accordingly pitch it to the seeker or the buyer, because a developer won't be able to pitch it to the buyer. So TTOs play a very crucial role in the technology transfer uh, systems. Now, once the technology has been developed with the facilitation available by TTOs, it has been reached to the potential buyer or the potential seeker. Now, next what? Like, the tech transfer process doesn't end here. It ends here with the maximum satisfaction or the maximum good feedback that we receive from the customers. So after licensing in the technology, this buyer, they would do their best to reach to the customer. So this is the whole process that takes place. Now the customers will give their feedback, like if it is really helping them, if it is solving their problems. So if the customers are still not satisfied, the buyer would not be able to manufacture it more, or will not be able to do it on the larger scales of the market. So what now needs to be done? Further development of the technology needs to be done, so that the customer should be, customer should be maximally satisfied, like what they are receiving. So this is a process that goes on. This is not just a one-time process. This is a multifaceted process. And this process goes on. Like, once the technology is developed, then transferred, then brought to any negative feedbacks will definitely go to the buyer again, the industry that has worked upon it. They'll further, put their expertise and then revise the product. So this is a process that goes on and leads to further innovations. It leads to further research and development, and that's how as a nation we develop. Because whenever any tech transfer happens, the commercialization happens, the direct connect it has with that, the initial stage of the technology development. So in case the industry is not able to revise it or revamp it, what they'll do, they'll again contact the developer. Then the developer will again go into the research and development, and that's how this whole ecosystem runs. So like, I am a part of this organization, Innovation Tech Transfer Office, and how we are helping in such tech transfer cases is, the first is the by helping our clients, academic institutes, or even the startups or industries, to help them with the formulation of right strategies. So IP strategies has been discussed by by my colleague Ms. Sani. So like, additionally, there should be tech transfer strategies as well. So since IP and TT, they both are interlinked, but again, they need to work in independence as well, because not every IP gets translated and not every technology is IP protected, right? So we help them with these strategy formulations, because if we talk about IP protection, so IP protection might have some specific set of rules that we receive an application, then like as an IP and TT cell, IPTT cell receives an application from such and such faculty students. Now, the next step would be the assessment part. The next step would be drafting. The next step would be the filing. But if we talk about tech transfer strategies, they completely differ from the IP thing. The person who has received the disclosure for tech transfer, they need to understand just not the technology, they also need to understand the market potential of the technology. They need to know the commercial viability. They need to know how good it would behave down the 5 years line. It's just not the matter of present or the current current time. They need to look, because only then they can scout for the technology accordingly. So it's very important to calculate the value of the technology, just not on the technical strength. Even it depends upon the market potential. Then there comes the technology readiness level. Then how far it can go, and in what other applications it can be benefited, like what different domains or what different industries it can target. So the very the one very common example is of the drones. So nowadays many startups are working on the drones, but all have different application areas. Somebody is working on agricultural drones, somebody is working on the drone shows, drone lights. So everyone has different, they have their chosen expertise, they have their chosen objectives. So how, but if you look at it, there is a, like, the technology is the drone developing, but they are customizing their drones to be developed for a specific purpose. The very recent that came out was the drone technology for the delivery of the medicines. So every, every customized tech is serves different purpose. So the person who is analyzing the technology should, must analyze what other different application areas it can serve, so that the, technology reaches out to the maximum, it gets a larger dissemination. So we are helping with such strategies. Other than this, what a TTO and IP cell does, they, of course, if they are helping in tech transfer, so they must have some connects to which they can reach out in terms of academia and in terms of industry. Because we come across, in industry problem statements as well. So now what, because we would, like, we should know whom to connect them with, so that that gap is bridged. Industry people can present their problem statement to the academia, the academia can work upon it. Once they work upon it, we can again present it to industry, and then they can, test it, check it, like if that is okay, or it still needs to be, researched, like research beyond this point. So again, this is a, a loop that goes on. So that's the most significant role of what an IP or a TT cell does. Now, why we all talk about the Atmanirbhar Bharat, local for vocal. So it all revolves around the tech transfers. It all revolves around the innovations, the creativity, the IP. Everything is, interlinked and interconnects with each and every component. So the most important and the beautiful aspect of having an IP protected or having some tech transfers is the that it improves the quality of life. So as I mentioned, like whenever a tech gets into commercialization, it definitely will, have a negative and the positive feedbacks. Positive feedbacks will motivate the, industry, will motivate the developer, but the negative feedback will help them to research it more. So when that research it more phase comes, they come up with the next innovation, and that's how the life gets improved of the society. And other than this, if anything, the academia has different projects going on. So in case they are doing well in terms of innovation, then also they are creating jobs, because manpower is associated with every step of the innovation development, with every step of the tech transfers. So it is helping you to create jobs. It is, it is a continuous revenue stream for the academic institutions, because whenever a tech gets commercialized, the academia has its own share of royalty, has its own share of funds that it can utilize further in the research and development. So as I was mentioning, like how as a TT person, or how as a TT professional, we start with the things. So firstly, uh, whenever we receive a disclosure for the technology that needs to be taken care for the transfer or for the licensing or for the commercialization, so we start with the tech assessments. So tech assessments are very important. We cannot just abruptly or bluntly start with the tech transfer process, because until and unless I'm sure about the technology that I am pitching to somebody, how can I convince them? Right. So I should be convinced first that it has potential. This has, optimal technical strength, which needs, which needs a proper addressal, which needs to come out, which needs to be, make people aware that yes, certain innovation is there, and this is bridging this gap. Then it needs to work upon the assessment looks for the IP strength. Now the IP strength would not just be look for the patents. It would be looked for different forms of IP. So whenever a technology is in one form of IP, it brings you an IP portfolio. The valuation of the technology increases multifolds, because now you can approach somebody and tell them that you have got multiple exclusive rights, kind of a bouquet for them, so they can exercise it however they want it. So IP strength plays a very crucial role, but again, IP strength is not the limitation. The next aspect that is assessed are the market needs. So by market need, I mean like how the technology is presently staged at the market level, and how it would be staged down the 3 years line or 4 years line or five, because each technology has a specific shelf life. So when we talk about the digital things, so the most important IP that comes up for the tech transfer is the softwares. And softwares have very short shelf life of getting a transfer, because they are easily hacked. They can be easily decoded, and uh, the revisions, uh, uh, the software that has come today, it might have some revisions in maybe by the next year. So the software that I have developed has its market value almost like maybe if not near to zero, but then it won't perform much if a revision is came, or if a specific needs a specific bug has been addressed. So in such a case, in case of softwares, the shelf life is very low. So in that case, in case anybody has worked out on algorithms, or anybody who has worked on a code, that should be protected at the earliest. That should be registered under copyrights at the earliest, so that the next step could be taken care of. So I facilitated one software licensing, though it was it was developed as a rural as a part of a rural project. So like we identified the buyer before we filed an IP for it, because when the project was initiated, we started looking for what could be the potential buyers to it, how how this technology would bring out that friendliness. And based on our research, we identified the potential buyers before the IP filing. We filed it on day one, and the next day we were ready to transfer it out. We were ready to license it out. So that's how the software thing needs to be run. It shouldn't, it is highly time sensitive, unlike the other IPs. Now, as I mentioned, looking for the TRL levels, the technology readiness levels, is a assessment, like how much a technology is matured. Like if it is an early stage, like the lab one. So in case it is a lab scale technology, then the technology involves a high risk of getting a transfer, because the other stages, late stage technologies, they have lower risk. hence maximum absorption, maximum licenses, maximum transfers. So one should not just work for the lab scale, they should target their approach beyond the lab scales. Now if we talk about like how the other aspects that we cover during the assessment is again that areas of application that I have mentioned, and what are the different advantages that the technology is bringing. So by different advantages, it could be, it could be as simple as mere reduction of time or mere reduction of human efforts. So it could be as simple as that. So anything, so identifying those key strengths, identifying the USP of the technology, help us to pitch it better, help us to look for more prominent industry partners. Now let's now understand what could be the different types of the tech transfer processes. So first is the licensing. So licensing is actually a broader term. It comprises of again two sub components: in licensing and then out licensing. So for example, I am looking for some tech solutions, and I got some from my friend. So I have licensed in the technology, and my friend that has lended me the technology, he has licensed it out. So in a single process, in licensing and out licensing, both are involved. The person who is absorbing the technology is facilitating the in licensing. He is licensing in that technology from the person who has developed the technology, who has out licensed it. The other form is the assignments. So assignment is something that I have given up my rights over the technology. When we talk about licensing, I'm not giving out on my rights. So if I have developed something and I want to license it out, that would mean that I am giving it for a specific period of time, for specific terms and conditions, and for specific for example, if I am not capable of manufacturing it at a large scale, so I'll be licensing it out to somebody or to some organization who can manufacture it for me, who can only manufacture it for me. I am not licensing them out for any other usage. I'm not licensing it out to them to use it, to sell it. No, I'll be using it, I'll be selling it. I am only giving them rights to manufacture my technology. So licensing could be that specific. But if we talk about assignments, so assignments include I'm giving up the entire technology. Bhai kar lo jo karna hai, mujhe nahi karna. So that's the case of the assignments. So assignments are generally not not healthy for a academic kind of a setup, because once they assign their rights, they no longer hold the rights for the research and development. So it's always recommended for the institutes, for the academicians, to always license out their technology and always keep those R&D rights with them so that they can further research, right? Because academia is something which is researching and developing things that are being further developed by industry, but the originators are the academia. So academicians must always give it a thought, or retain those rights with them, retaining the rights for further research and development on the technology. The third form is the joint ventures, or you can say the co-development. So this also happens in the academia. So what happens, for example, as an industry person, I have some problem statements. I visit an industry, I tell them my problem, and they say that yes, it can be worked upon. So I'll be sponsoring them, I'll be investing my resources, and they'll be working it out. So this was be a co-development. In such cases, if IP is generated, then the IP is owned by academia and the industry people both. Now, what are the tools for tech transfer, or what is the backbone of tech transfer? Like how one can facilitate the smoothest process for a tech transfer without any glitches, any discrepancies. So the first thing that policy framework. So be it an academician, be be it a startup or even a lone innovator. So you need to follow a specific set of rules. In case it is not there, then you'll face the challenges in terms of ownership rights, or in terms of revenue distribution. So there are different policies with every institute. So if we talk about IT Delhi's technology, IT Delhi's policy for the tech transfer. So they have very specific set of ratios, 60 to 40 ratios. So 60%, so in case of any revenue generation during the commercialization, so the 60 directly goes to the PI who has developed the technology, and the 40 goes to the institute. So the 60 part of that revenue goes to the PI, and then he can further allocate whatever he feels right among his students or among the rest of the inventors. So that should, the policy helps all the people or all the stakeholders of a system to be on the same page. जिससे बाद में है ना, because what happens when you have developed a technology and you are least aware of how this would come up in the market. But once the revenue starts generating, so you should already have some contracts, some agreements in place, so that there are no glitches or there are no future disputes over it. So policy framework is kind of a mandate, and it's kind of a backbone to a tech transfer. Then the second tool, but the second most important thing comes up is the type, or the the specific agreements that you need to have in place in order for a smooth tech transfer. So if you talk about licensing, so there are license agreements. So what license agreements generally comprises of? They comprises of the specific tenure of that agreement. They comprise of the milestones that will be reached, at what stage that particular milestone the industry or the person who is absorbing it needs to achieve, how would the payment would occur, what would be the type of agreement, if it would be exclusive, it would be non-exclusive. So the type of exclusivity comes with the type of the potential seeker or a buyer. It completely depends upon them. You can pitch for exclusive, you can pitch for non-exclusive. So if the by exclusivity I mean, for example, I have we have developed something, and now we are looking for commercialization partners. So one industry wishes to have exclusive rights over it. So by exclusivity, they mean they wish to have all the rights with them. Like they want us to not give it further or to not license it further to any other organization or any other company or industry. They wanted to have exclusive rights over the technology. So in such cases, of course, the upfront payments, the royalty is high. But when we talk about non-exclusivity arrangement, so in non-exclusivity, a technology can be licensed out to multiple organizations or to multiple people, not just one organization. So that's how the exclusivity and non-exclusivity works when we talk about the licensing. Next is the non-disclosure agreement. So it happens very often when we talk about confidentiality or non-disclosures of that confidentiality. So when you are presenting something, or even if you are presenting to any industry your technology, how should you go about it? do not disclose the entire technology. Do not disclose the know-how, because of course the industry people, they are very quick. They are very good in reverse engineering things. So in the first meeting or the second meeting, keep up the confidentiality with you. You can explain about the USP of your technology. You can talk about the advantages. Talk about the unmet need that it is filling, or the gap that is being bridged. But you should not disclose what the components, how they were assembled, or what was the algorithm, what was the formulation, how that formulation was prepared. You should not talk about it unless and until you have signed a non-disclosure agreement, NDA, with them. So we, as tech transfer professionals, we take care of such things. We know how much to disclose, and up to what extent one should disclose. So non-disclosure agreements are must. And then the clauses that needs to be there in the non-disclosure agreements should be very, very specific. We cannot sign an NDA for an indefinite time. It should be as specific as 3 months or 2 months, or even a week. Like, in case it is not a rocket science kind of a technology, so one industry can of course decide within a period of a week or two that they are interested to know more about it or not. In case they are not interested to know more about it, no need of sign an NDA, and no need of sharing of information. But yes, if they are expressing their interest that yes, this technology looks prominent and we want to know more about it, then we should propose an NDA with them. So once the NDA is in place, both academia have signed, industry have signed, then you can go about and sharing the information with them. Because that would make sure that your confidentiality is with you, and it would not be disclosed even if the transfer doesn't happen. Because NDAs are not a proof that technology will transfer. It is a step, you can say. It is a next staged step that helps the potential seeker or a buyer to know more about your technology and then decide further. Then the next important aspect of technology transfer is the marketing content. Again, once we have analyzed the technology, once we have assessed it, now how to portray it, how to showcase it. So there could be different methods of it. We portray the technologies which are with us through tech briefs, through brochures, through our newsletters. But whatever we are publishing, whatever we are sharing, it doesn't contain any confidential information. It contains only non-confidential information, even if the IP is granted. But even if the patent is granted, you need not to tell them the patent number, the grant number in the first discussion, or even during the advertisement or the marketing part. Because not let anyone destroy your efforts just because you want to come up with the procedure fast. Technology transfer, of course, is a time-taking process, and it is good you take time before we reach to any blunders. So any marketing content for a license, for licensing or technology transfer needs not to have any confidential information about the technology. It can include USP, it can include a brief on the tech, it can include the advantages, it can include what are the challenges that it has overcome. So, like, market it out. So, when I talked about the policy frameworks or the need of the policy framework, I talked about the ownership issues. So, so the policy, like as I mentioned, so when we talk about the academic researchers, so academic researchers are generally generated out of the academic resources only. So in such cases, IP ownership should be with the institute, should be with the academia. But there have been cases when faculty is unknown, like unaware about the policy framework, or maybe in the absence of such policy framework, what has happened. We have certain cases where the faculty or the inventor files the IP in their name, right? But they have utilized the resources of the of the university or of the institute. So ethically, it should be filed in the name of institute or then academia. So a policy framework helps everyone to be on the same page, so that no ownership issues arises later. Because IP is just not a matter of a day, one day. It is a matter of continuous, at least for a period of 6-7 years. Even if it is even if it gets a grant by paying certain fee every year. So the institute can take care of such expenses better than an individual inventor or than a faculty, because the drafting part, then the filing part, then the prosecution part, everything involves a cost, and academia can work better over it. So the policy frameworks are generally made that way, so that if even if in case an IP is filed, it can be maintained, it can be protected well within the timelines. And the second aspect of the policy framework is how the revenue sharing would occur. So that I've given you an example of the 60-40 ratio. The 60 goes to the PI and the 40 goes to the academia. So that's how it keeps motivating the inventors, the faculty, the researchers to that's revenue helps them motivate to do further researches and brings more innovations to the people and the society. So this we have already covered, like how should we market. We can prepare tech briefs. We can have separate marketing strategies. Marketing strategies would be one-to-one, like generally we like what are the marketing strategies that we follow at ITTO. We will reach out to the companies, we visit the exhibitions, we visit conferences, seminars with our tech compendium and the person who have assessed the technology. So if not this, then we generally we also use the social media, like LinkedIn is the best way to showcase your technology, even the Twitter. So you can strategize accordingly as per the need of your technology, on which social media you need to strategize it. So recently one of our clients, they have partnered with a well-known Bollywood actress. So the actress is investing plus is partnering with that startup, and that's how they have marketing it, like that. That's how they have strategized their marketing strategy. So it could be anything. It completely depends upon the requirement of your product. If it needs to be well endorsed with the famous personalities, or if it needs to be showcased in the conferences, in the seminars or exhibitions. So it completely depends upon the type of technology, the type of product that you are marketing. Now, whenever we are, going for any tech transfer agreements, licensing agreements, what should be, the foremost requirements? Firstly, set the milestones. So even when we have transferred a technology, or even when we have licensed it out, there should be set milestones. Set milestones so that the person who is absorbing the technology, or who promises to work on it, should or must work on it. We are not letting him have our technology to waste time or to sit over it. No, we are not giving it for free, because this is actually a real case scenario. Some industries, what they do, they absorb a technology because that technology was a competition to their original work. So what they'll do, they'll absorb the technology at any cost, and now they will just sit over it because they have now exclusive rights over those technologies. They just sit over it and let it die. So always set the milestones. Your technology should work out. If it is not working out, work out the reasons why it is not working out. Let them explain, and if they are unable to explain, you can terminate the agreements, and you can give it to somebody else. So always set the milestones, and the best, and recruit the best people who can facilitate the tech transfers, because as a researcher you might not know about the different aspects of legality or the techno legal things that are involved in such transfers. But then tech transfer professionals or IP experts, they can help you better, of course, better with those. So there are certain do's and don'ts that one should always keep in mind before going for a licensing. So you should always have a clarity on type of transfer. So the type of transfer I mean, like, what kind of a transfer you are looking for. Like, if it is a licensing only, if it is an assignment, or if you are looking for a co-development. So you should know it beforehand, before you are scouting or before you are approaching an industry. You should know what kind of a transfer you are looking. Then all agreements should be in order. Like, in case if you require any validations, if you require any uh, trials, so that should be in place. If you require any NDAs or any such things, they should all be in place. And the third point that I've mentioned is that academic institutes should reserve the future research and non-commercial rights with them. This is very important if we talk about academia part, because there have been cases when academia has given upon its entire rights, not and they did not retain even the R&D rights. What will happen next? They'll not be able to do anything about the technology, even if they are completely capable, competent enough to further develop it. So making a technology die. So this is very important. Other than this, the what should be the don'ts? Lack of confidentiality terms. Revise your NDAs as many times as you want before presenting it to the industry, because a single loophole will maybe will not be healthy for a technology. Will not be healthy for your technology. Always clarify on the upfront payments. Like, this would be the upfront. For example, I am licensing out some technology in 10 lakhs. So I should be very clear. If the 10 lakhs, it should be paid upon the signing of agreement, if it should be paid in the milestones, or how it should be paid. It should be very clear in those agreements. Setting up of the milestones, then royalty amount, how the royalty will be decided, at what stage royalty starts, on what numbers it should be given. And the next would be type of agreement, how it would be, if it would be exclusive, if it would be non-exclusive, if it would be exclusive, then if it is for the specific territories. So everything needs to be worked out before you sign those license agreements. Now with this the whole exhaustive tech transfer system, there are certain myths that are associated, though I tried to address them during the session, but I'll just still quickly recap those. So, can any technology be transferred? So no, not every technology can be transferred unless and until it has some potential, or unless and until it is bridging the gap, meeting the unmet needs. Only then it can be be considered for a transfer. Is IP protection must? So again, no, IP protection is not mandatory, is not necessarily should be. Yes, if IP is there, the chances of getting a transfer. So do you need a granted IP to get a transfer? Again, no. Even if you have a filed IP with you, the day, like, you should start the tech transfer process the day you file an IP. You need not to wait till it get a crack. Then the next is, can anyone transfer a technology? So again, I would say not everyone can transfer a technology. It takes a tech transfer professional, the experts, to transfer or to facilitate a technology, because they know it better. Like, what should be the negotiation terms? How should the technology be evaluated? Because for every inventor, for every researcher, their technology is unique. But when we talk about real case scenarios in the form, it can only be true assessments. So a technical professional will help you do that assessment. That's all from my end.
Thank you. Thank you so much, ma'am, for sharing your expertise with us. Your contribution has been instrumental in guiding all of us in future. Thank you so much, ma'am. Now, I would like to invite Dr. Hema Sukeja, co-convener of this event, for the vote of thanks of our today's resource persons.
Good afternoon to all present here. I, Dr. Hema Sukhija, Assistant Professor in Mathematics and co-convener of this national seminar, Innovative Trends of IPR in Digital Era. In this technical session, two resource persons are with us. Ms. Rima Sahani, Head Innovative Technology Transfer Office, Foundation for Innovation and Technology Transfer, IIT Delhi. She talked about IP strategies in digital age. Thank you very much, ma'am, for sharing your insights on IP strategies in digital age. Your expertise has been incredibly valuable and has provided us with a clear understanding of navigating this complex landscape. We truly appreciate your expertise and time. Thank you very much, ma'am. And as a second resource person, Ms. Pragati Agrawal, Project Manager, Innovation Technology Transfer Office, Foundation for Innovation and Technology Transfer, IIT Delhi. She talked about digital licensing models. Ma'am, you have very beautifully explained this topic. Rima ma'am is also here now. So thank you very much, ma'am. You have shared, you have discussed a very beautiful manner what is IP, and you have given a lot of information regarding this topic. And as in this era, this is very essential for all of us, for all researchers and for all industrialists, etc. So thanks a lot, ma'am. And now, thank you very much, Pragati Agrawal, ma'am. You have also explained enlightening discussion on digital licensing models. Your insights have provided us with a deeper understanding of their intricate subject, and it will really be instrumental in our future endeavors. And we are grateful for your expertise in this field. You have also told us how can we create, how can we generate value by our research. Yes, Anita ma'am, you are saying something. You have also explained transfer of technology from innovator to industry, techniques of technical materials, equipments, policies, significance of technology, technical transfer, technology assessment. This topic is very wonderful, and you have explained it a very innovative manner and elaborative manner. And both of you have explained, have clarified these topics, and truly the topic of our national seminar is really your talk is very fruitful for all of us. So thanks a lot, ma'am. Thank you very much.
Thank you. Thank you.
Thank you so much, ma'am.
Thank you so much, ma'am. Dear delegates, it is now time for an half-hour lunch break. Kindly return to join your respective track coordinators at 2:30 p.m. Additionally, validity session will begin promptly 4 o'clock, so please ensure you are present and ready to participate. Thank you for your attention and cooperation. Thank you. Thank you all. May I start, ma'am?
Yes, Rosie ma'am.
Thank you so much, ma'am. A very good afternoon, all present here. Welcome you all in this one-day multidisciplinary national seminar. I, Dr. Rosie, session coordinator, welcome all in validity session. I would like to extend a special welcome to our worthy chief guest and keynote speaker, Dr. Nitin Goyalji, Department of Computer Science and Engineering, Central University, Mahendragarh, Haryana. I heartily welcome our Honorable Management Committee of Arya Kanya Mahavidyalaya Shahabad Markanda. And a warm welcome to respected Principal Ma'am Dr. Aarti Trihanji. Welcome all dignitaries, delegates, and members of press. I also welcome convener, co-conveners, and members of all organizing committee, teaching and non-teaching staff. Welcome you all. Now, I would like to invite Honorable Principal Ma'am Dr. Aarti Trehanji for formal welcome of sir. Please, ma'am.
Thank you, Dr. Rosie. Very warm greetings to all of you. Distinguished Chief Guest of Valedictory Section of today's multidisciplinary national seminar, Dr. Nitin Goyalji from Department of Computer Science and Engineering, Central University, Mahendragarh, Haryana. Respected President of Arya Kanya Mahavidyalaya Shahabad, Shri Ramlal Gupta ji, members of Managing Committee, worthy dignitaries, esteemed resource persons, worthy delegates from all over India, press correspondents, worthy faculty members of our college, members of Advisory Committee of Seminar, convener of National Seminar, Dr. Swati Atri, co-conveners, Dr. Poonam Sivaj and Dr. Hema Sukhija, organizing secretaries, coordinators, and all the members of organizing team. Good afternoon to all of you. At the onset of valedictory session of THE sponsored and approved national seminar on innovative trends of IPR in digital era, organized by Research and Innovation Cell of Arya Kanya Mahavidyalaya Shahabad, I extend a very warm welcome to all who have joined us today. We all know various intellectual properties are being created in various fields of human endeavors. In this dynamic environment, where ideas flow freely across borders and platforms, it becomes imperative for us to understand and adapt to the evolving trends in intellectual property protection. There are a number of challenges and complexities in protecting intellectual property rights. The emerging digital networked environment is also posing challenges to existing intellectual property law, requiring a rethinking of copyright law. The development of an efficient ecosystem for guaranteeing intellectual property rights adapted to meet the challenge of digital economy requires both a strengthened and regulatory environment and better competencies. In this context, today we gathered for acknowledging these challenges. This seminar served as a platform for sharing knowledge, insights, and experiences, fostering dialogues and collaboration among experts, practitioners, and enthusiasts in the field of intellectual property. Throughout all the sessions, delegates delved into various innovative trends shaping the landscape of IPR. From the emergence of new digital technologies to the evolving legal frameworks governing intellectual property, each discussion offered valuable perspectives and actionable insights. So during these pride moments of Arya Kanya Mahavidyalaya, I feel highly privileged and honored to welcome our esteemed and distinguished chief guest of valedictory session, Dr. Nitin Goyalji from Department of Computer Science and Engineering, Central University, Mahendragarh, Haryana. A very hearty welcome to you, sir. You are going to enrich all of us today with your expertise views. I also express my gratitude to you, sir, for sparing your valuable time for our national event. I also welcome all the dignitaries, resource persons of technical sessions, and delegates, media persons, and express my gratitude for being us for today. I also acknowledge the support extended by our management and members of Advisory Committee of National Seminar. I congratulate convener of National Seminar, Dr. Swati Attri, co-conveners Dr. Poonam Sivaj and Dr. Hema Sukhija, organizing secretaries, coordinators, and all the members of organizing team for organizing the national seminar. With these words, thank you all. Jai Hind, Jai Bharat.
Thank you very much, ma'am. It gives me immense pleasure to introduce such a dynamic personality among us, respected Sir Dr. Nitin Goyalji, Chief Guest and Keynote Speaker in this valedictory session. Dr. Nitin Goyal is currently working in Computer Science Engineering Department at Central University of Haryana, India. He also worked as an assistant professor at Shri Vishwakarma Skill University, Haryana, India. He has a PhD in computer engineering from NIT Kurukshetra. He is specialized in underwater wireless sensor networks, having application of military operations. He obtained his BTech in 2007 and MTech in 2009 from Computer Science and Engineering at Kurukshetra University, Kurukshetra. He has around 14 years of teaching experience along with academic work. He has published approximately 100 research papers in various international and national journals, books, and conferences, out of which 50 are SCI, 3 are Scopus, 11 are book chapters, and 27 are conference papers. He has filed around 25 patents, out of which 7 are published and 3 are awarded. Also, he has attended 13 workshops and 3 FDPs. He is the editor of 3 books from different publishers such as IGI Global, Bantam Science, CRC Press. He has guided 10 MTech candidates and 2 PhD candidates. He has also delivered 7 expert lectures on NS2, paper writing, patent filing, innovation, and entrepreneurship. He is a GATE, HTET, and UGC NET qualifier too. He is currently working in the area of UAVs in underwater communication networks to solve some real-world problems. He is a senior member of IEEE. He has been the guest editor of SCI Index Reputed Journals from SEC and MDPI publications. He is on the reviewer panel, editorial board member for many journals of repute, and also a session chair in many international conferences. Sir, we would be honored to have you as our chief guest and keynote speaker in this seminar. Your extensive knowledge and experience would greatly benefit for all of us. Now, I would like to invite respected Sir Dr. Nitin Goyalji for enlightening us on the topic of IPR, a practical solution. Please.
Thank you, ma'am. Thank you. First of all, please see that my slides are visible or not. I'm going to share the screen.
Okay.
Is it visible to everyone?
Yes, sir.
Okay.
Okay.
Yeah. Is it okay? Is it movable? I am on second slide. Is it okay?
Yes, sir.
Okay, fine. Thank you. So thank you very much for this opportunity given to me as the keynote speech for this multidisciplinary national seminar. A hearty welcome has been done by the from the management side and from the principal, Dr. Aarti Trehan, Dr. Swati, the convener of Research and Innovation Cell, Dr. Rosie, thank you. Thank you, Dr. Hema and Dr. Poonam. Thank you for organizing this wonderful seminar. I am into this seminar since morning, and I am also seeing that a lot of discussion was going on by various experts like Dr. Reema Sahni, Dr. Naresh Kumarji, and Miss Pragati as well. So a lot of discussion till the morning is going on, and it gives me it gives me the confidence to smooth conduct this session as well, because उन्होंने मेरा काम बहुत अच्छे से सॉल्व कर दिया है. Starting has been done very well by those people. So thank you, the organizers of this seminar, for beautifully placing all these experts in a way कि जो audience है उनको step by step सब कुछ समझ में आता रहेगा. Now
Sir, you are not audible.
Yes, it's not audible.
We cannot even see the slides.
Please wait a minute. I think network issue.
All the participants are kindly requested to wait for some time. I think there is a network issue at speaker end.
No voice, ma'am.
Uh, Please wait, ma'am. There is network.
There is a network issue at the speaker end. He will be connected soon, so kindly wait for some time.
sorry, am I audible and visible as well?
Yes, sir.
Fine, thank you. And now my screen is also visible.
Yes, sir. Visible.
Okay, so I was at this slide when the connection got cut. It is the second slide actually. So I'm at the right slide.
Yes, sir. You may continue.
Okay, thank you. So I was discussing that since morning we are listening that what is IPR, and we are at the conclusion that IPR is something who is able to protect our creation, our invention, and also help to earn recognition that may be in the name of fame or financially. So both the way it will work. So that is something we are getting from the IPR. So I'm not discussing much because from the morning we are listening to this. But do you know some of the facts about IPR in India? Here it is first fact. 1.2 million patents have been filed since last 5 years by India. So that is one fact. And another fact is that more than 75,000 trademarks are registered in the last year only. So this is the key fact about India, that we are progressing nowadays in case of patent and trademark. And I believe that after my session, you yourself will be able to file at least one patent. We will be discussing this in detail, and you already have an idea in your mind that how to get it patented. I just have to guide you. I just have to tell you. Okay. So what is the base of any of the patent? It is somehow related to research, because what we do in research, we go from perception, that this is our perception, it should be something like this, to confirmation. अब वो वहां तक पहुंचते कैसे? Our first stage is we go first into the preparation mode. Preparation में क्या होता है? सबसे पहले we come into restless mode. So we have to come in restless mode. And if we are into the restless mode, then only we are able to do something. We are able to create something. We have to see the problem from the surroundings. हम कभी किसी प्रॉब्लम को फेस कर रहे होते हैं तो we think of this कि this can be the solution. ये हो सकता है, इसका ये solution अच्छे से possible है, इससे ये problem दूर हो जाएगी. That comes to innovation, that comes to idea, that comes to research and the patent, trademark, copyright as well. Next, we go towards step is the development, where you find the solution. जहां हमें लगा था कि अच्छा ये प्रॉब्लम आ रही थी तो इसका ये सॉल्यूशन पॉसिबल तो है, ये डेवलपमेंट अगर की जाए तो दैट इज बेस्ट फॉर अस. Thereafter, the next step we think of is the indication. आपने प्रॉब्लम सोच ली, उसका सॉल्यूशन सोच लिया कि इसका सॉल्यूशन कुछ ऐसा होता है, तो क्या आप उसको प्रैक्टिकली और यू कैन से इन द फॉर्म ऑफ प्रोटोटाइप बना करके देख सकते हैं? डू यू हैव एनी इंटीमेशन अबाउट इट कि अगर ये सॉल्यूशन करें तो इसका इंपैक्ट क्या रहेगा? क्या ये किसी और प्रॉब्लम को जनरेट तो नहीं कर देगा? वी हैव टू थिंक अबाउट दैट एज वेल. अभी क्या है कि इफ यू हैव टू टेक एनी लिक्विड, सो यू प्रेफर्ड इन द स्टार्टिंग द पॉलिथीन, बट पॉलिथीन क्रिएट करना आसान है, डिस्ट्रॉय करना बहुत मुश्किल है. सो उसने जो है कचरे को क्रिएट कर दिया अर्थ पे. सो दैट वाज द अनदर प्रॉब्लम दैट वाज क्रिएटेड बाय अ सॉल्यूशन. Enlightenment. When we found solution to the problem, this is that step कि अच्छा इसका ये solution हो सकता है, and that is also not problematic. Solution is also good. That is not going to generate any other problem. Or there is a problem of that, there is a solution of that problem as well. And thereafter at the last, it comes to the confirmation. When you have already applied it, you see कि ये तो solution confirm सही है. Now there is no problem into this solution. Some good results you are getting. So for that good results, confirmation is required, and that confirmation comes from your all step-by-step evaluation of this research. Now you will see that a person is doing PhD or wants to do PhD or maybe guiding the PhD candidate. He just sit कि मुझे आज तो रिसर्च करनी है. He just sit in a way कि आज तो मैं शाम को 5 बजे से लेकर 9 बजे तक बैठ के रिसर्च करूंगा. I'll think of this and I'll generate something new. But practically, all of you must be agreed with this. जिन्होंने भी PhD कर ली होगी या कर रहे होंगे, that is not possible. Any kind of research, if you are doing so, any kind of patent product you are generating, उसका जो भी idea है ना, that will always come at the bad time. अब वो bad time कौन सा है? It is something like you are driving. It may be खाते हुए कुछ idea आ जाए. इट में भी जब आप सोने के लिए जा रहे हो ना, उस समय कुछ आइडिया है. इवन दैट हैपन विद मेनी ऑफ द साइंटिस्ट. दीज पीपल आर स्लीपिंग and in the midnight the sleep get disturbed, they just waken up, they think of some solution. Then what to do with this? If you are having any of this solution at your mind at these bad times, good time is what? That you are seated for the research. Bad time is what? You are not seated for the research, you are doing something else. So what you have to do in that case? Just fast as just come and go and write it wherever you want. इसको बाद में सॉल्यूशन को देखना है. मैंने ये कहीं लिखा था, क्योंकि उसके बाद वो दिमाग से चला जाएगा. इट हैपेंस विद मी, प्रोबेबली इट मे हैपन विद यू एज वेल. किसी के साथ और ऐसा हुआ है? आई जस्ट वांट दिस सेशन टू बी द इंटरेक्टिव वन. प्लीज अनम्यूट योरसेल्फ, यू कैन से ये अच्छा आइडिया आया पर बुरे टाइम पे आया. Are you with me? Am I audible?
Yes, sir, audible, sir.
Okay, fine. So, is it so कि ऐसा कुछ हुआ हो कि अच्छा आइडिया तो आया बट बुरे टाइम पे आया?
It happens, sir. It happens.
Yes, sir. It happens many times.
Okay, thank you. मुझे लगा अकेला मैं ही हूँ ऐसा. ठीक है, और भी लोग हैं. So confirmation is there. सो उसको आइडिया को लिख लेना है आपने, बिकॉज उसके बाद वो आकर के एकदम से चला जाएगा. देर आफ्टर आप उसको ढूंढते रह जाएंगे ये था क्या. अब प्रॉब्लम यही आती है, आपने आइडिया लिख लिया, उसका सोल्यूशन लिख लिया, ये तो पता नहीं कि पेटेंट करेंगे कैसे. सो व्हाट इज द प्रोसीजर? द प्रोसीजर इज अगेन पृथ्वी की तरह ये भी गोल 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 है. पेटेंट का सोल्यूशन इज ऑल्सो what to get patented is also round. In this round circle, first is the publication. अभी इसको भी डिटेल में डिस्कस करेंगे हाउ टू डू इट. फर्स्ट इज द पब्लिकेशन. यू हैव टू गेट योर पेटेंट publicized with any of the, you can say in our India we do have 4 offices, Kolkata, New Delhi, Bombay. So we can get it at any place. Normally we the people of North India go towards the Delhi. Then the second step that is done by them is the examination. They examine your patent. The patent officer is there. He examines whatever your claim is. You will get some kind of response that your patent is good or not. Your patent have this kind of problem that you have to solve. Then thereafter, on the basis of that response, you have to make some amendments. आपको अपने पेटेंट में कुछ चेंजेस करने पड़ सकते हैं. Or otherwise you have to satisfy the questionnaire by that patent officer. You have to take some compliance for solving that. Thereafter your patent will get granted. But what after that? Patent grant ho gaya, what you will do? You need to have some renewal also. After some of the or certain of the years, you have to re-evaluate it, get it re-evaluated, get it renewed. उससे क्या होगा रिन्यूअल से? वरना आपका पेटेंट जिस टाइम पीरियड के लिए, जितने टाइम पीरियड के लिए आपको मिला था, उसके बाद वो खत्म. फिर सेम पेटेंट किसी और को आइडिया आया हुआ है, आपने पब्लिसाइज किया हुआ था, कोई और ले लेगा. इट कैन बी डन. सो यू हैव टू गेट इट रिन्यूड आफ्टर द एक्सपायरी. सो व्हाट इज देयर? एनीथिंग न्यू इज द पेटेंट which should be actual, inactual or undiscovered. You can get patent of what? You can get patent of any design. अपना कोई लोगो बनाइए, अपनी यूनिवर्सिटी का, कॉलेज का लोगो बनाइए, उसको पेटेंट करा लीजिए. You can do so. Any of the utility patent is also there. कोई यूटिलिटी की चीज है तो आप उसको पेटेंट करा सकते हैं. Even you can get your research paper as well. आप अपने रिसर्च पेपर का पेटेंट कराना चाहें वो भी करा सकते हैं. You must have written some of the research papers during your research, your PhD, your MTech maybe. So you can get it patent. You can get patent with any of the thought. दिमाग में कोई थॉट आ गया, उसको भी पेटेंट करा लीजिए कि ये मेरा थॉट है, इस थॉट को नहीं कोई चुरा सकता. Any of the concepts that you have evaluated. कोई एल्गोरिथम आपने बना लिया, आप उसको पेटेंट करा लीजिए इससे पहले कि कोई और उस सेम एल्गोरिथम को पेटेंट कराए. आपका एल्गोरिथम किसी और के नाम हो जाए. So in any of the way you can get the patents. इनको नाम अलग अलग दे दिए जाते हैं. फिर किसी को कॉपीराइट कह देते हैं, किसी को ट्रेडमार्क कह देते हैं, किसी को यूटिलिटी पेटेंट कह देते हैं, किसी को डिजाइन पेटेंट कह देते हैं. सो दैट वेरीज. द थिंग इज कि आपके सोच में आया क्या. Now we do have four kind of the intellectual property rights. कौन कौन से हैं वो? One is the trade secret. जैसे कोक कंपनी है, कोका कोला, यू मस्ट हैव ड्रिंक इट. उसका जो फॉर्मूला है कि कितनी चीनी डलेगी, कितनी उसके अंदर सोडा डलना है, कितना कलर डलना है, all these things are the trade secret by the coke. And if you have something in brand, that comes to trademark. For example, Apple. एप्पल जो है वो अपना जो लोगो है उसको ट्रेडमार्क की तरह रखता है. इन द मॉर्निंग डॉक्टर नरेश वाज आल्सो गोइंग टू डिस्कस अबाउट इट. सो ट्रेड सीक्रेट और ट्रेडमार्क में फर्क क्या है? ट्रेड सीक्रेट इज समथिंग जो आप अपने पास रखे हुए हैं और आप उसको किसी के साथ शेयर नहीं करते हैं. लिमिटेड पीपल आर देयर टू एक्सेस दैट. सपोज कॉक जो है कितना किस एलिमेंट को मिक्स करता है ये किसी को नहीं बताता. दैट इज केप्ट सीक्रेट. और जहां पर ये मिक्सचर हो रहा है वहां पर एंट्री भी रिस्ट्रिक्टेड होती है. इन द पानीपत आई थिंक a plant of coke was there, so the entry was very much restricted in that area. That is the trade secret by the coke. कोई जा नहीं सकता. Even they have bond signed with the person कि अगर आपको हमारा सीक्रेट पता लग गया, thereafter still you cannot share it with anyone else. अगर आपने शेयर किया तो हम आपको कोर्ट में ले जाएंगे. एंड द ट्रेडमार्क इज कि पेटेंट जो होता है उसी का टाइप है ये. ट्रेडमार्क इज कि एप्पल ने कहा कि जो मेरे सेलफोन है उसके विद रिस्पेक्ट टू मैं कुछ ऐसा एप्पल वाला लोगो रखूंगा जो कि थोड़ा सा यहाँ खाया हुआ एप्पल होगा, तो आप उस एप्पल वाले जो ट्रेडमार्क है उसको कोई ले नहीं सकता. तो दैट इज समथिंग ट्रेडमार्क. व्हाट अबाउट कॉपीराइट? कॉपीराइट इज जब भी आप कोई बुक पब्लिश करते हैं, कोई मूवी देखते हैं, कोई ड्राइंग बनाते हैं, all that is getting copyrighted. You have copyright with you. आपने देखा होगा कि आपने कोई बुक चैप्टर पब्लिश किया, कोई बुक पब्लिश की, आप उसके विद रिस्पेक्ट टू कॉपीराइट का फॉर्म साइन करते हैं. एंड इवन somehow sometime पब्लिशर आस्क यू, he ask कि आपने कहीं किसी और की फिगर तो नहीं यूज करी, बनी बनाई फिगर उठा करके यूज कर ली क्या? वो आपके कॉपीराइट में नहीं है क्योंकि वो उसका कॉपीराइट है जिस पब्लिशर से वो पब्लिश हुआ है. So you must have to take permission in return from that person कि you are going to develop that. So that is the copyright. And in case of patent, it is something कि आपको, yes, someone wants to say something.
और क्या बोलते हैं, वर्क प्रेशर कैसा है?
वर्क प्रेशर
काफी है.
अशोक कश्यप जी, आप कुछ कहना चाहते हैं? I think mistakenly he switched the mic on. Okay. So patent is that protect you functionally or ornamental features as well. For example, iPhone का जो swipe का feature है, बाकी phones में कैसे होता है? You just swipe up, maybe swipe down, maybe click on the green button. But in case of iPhone, you swipe from left to right. So that is the feature of iPhone, which was patented by the company Apple. So ये feature जो उसका patent करवा लिया गया. Now, what are the utilities in these cases? Utilities are, if patent is of utility patent, अगर ये utility patent है, then you have the usage of around 20 years from the date of filing. Although it can vary, ये कम ज्यादा हो सकती है based upon the office, based upon the fees, based upon the criteria that you have chosen. If it is design patent, it is normally given for the 15 years from the grant date. Remember it. It is from the filing date. It is from the grant date. And trademark, as long as it is been in use, जब तक कंपनी चल रही है, एप्पल का, कोक का, जो भी उनका लोगो डिसाइडेड, ट्रेडमार्क डिसाइडेड है, जब तक वो कंपनी है तब तक वो रहता है. जब कंपनी बंद कर दी, क्लोज्ड अप, then there is no trademark. What is about copyright? It is your complete life plus 70 years also. जब तक जिंदा है तब तक तो है ही, जब मर गए उसके बाद भी 70 साल तक कॉपीराइट आपके नाम पर ही रहने वाला है. No one is able to use that. No one can use that. Is not authorized. Anyone from your family can take him or her to the court. Normally, it protects you from the functional aspect, design protect you from the ornamental features, trademark protect you from the brands, and the copyright from the authorship. Normally for the book, for the paper, these kind of things. Now, I'm going to take you in practical aspect. There are, because I have demonstrated it कि आप सभी का अपना एक पेटेंट होगा, आप लोगों को सिर्फ ध्यान से सुनना है कि पेटेंट में क्या और कैसे हो सकता है. Now, this is one of my patent. The name is aerial system for extinguishing fire. As the name suggests here, आग को बुझाने के लिए एक एरियल सिस्टम को डेवलप किया गया है. आग को बुझाने की जरूरत थी क्यों? वी डू हैव फायर सिस्टम, हमारे पास है ना. फायर अलार्म्स आर देयर, वी डू हैव द फायर वैन्स, spray of water is there. Why do we need it? The first benefit is कि आपको वाटर की सेवेज करनी है, वो इसके थ्रू होती है. सेकंड बेनिफिट इज जो भी एरियाज हाइट पर हैं आप उन तक भी ये ले जा सकते हो जहां पर आपकी वैन्स नहीं जा सकती. नाउ इसके अंदर प्रोसीजर क्या इस्तेमाल होता है? We do have sound by this area. Sound is there. Do you know that we can use this sound for any kind of hazardous situation related to fire? हर एक जहां पर भी आग लगी, किसी बिल्डिंग में, किसी ऑर्गेनाइजेशन में, किसी भी जगह पर, उसको आग को बुझाने के लिए एक पर्टिकुलर फ्रीक्वेंसी सेट करनी पड़ती है. आग का वॉल्यूम ज्यादा है, फायर इज मच मोर देन इन दैट केस. वो जो इंटेंसिटी है जिससे आप उस साउंड से उस पर अटैक कर रहे हैं वो ज्यादा करनी पड़ेगी. कहीं पर कम है तो कम करनी पड़ेगी. एंड वी प्रैक्टिकली डेमोन्स्ट्रेटेड इट. इट इज अवेलेबल. So for that reason, by having the savage of water and going on so much of height also with the help of a drone, this was possible. We get it patented last year with the title aerial system for extinguishing fire. So you can have a volume, high volume of intensity on that specific area जहां पर भी वहां पर आपको लगता है आग है, उसको आप उससे आग को बुझा सकते हैं. That is one of the patent. So if you have any kind of patent in your mind, आपको लगता है कि अच्छा ये भी तो मैंने ऐसे किया था, इसको मैंने पेटेंट क्यों नहीं करा लिया, ये तो किसी को पता ही नहीं अभी तक, यू कैन गेट इट पेटेंट. अब उसको पेटेंट करवाइए ना. ओके, हम लोग एक और आइडिया डिस्कस करते हैं. वन मोर ऑफ माय पेटेंट दैट इज आल्सो वेरी मच सिंपल. आप लोग सभी प्रोबेबली इन द मॉर्निंग you do have a matchstick while going to the temple or maybe at your home, और आप पूजा करते समय उसका इस्तेमाल करते हैं, उस दिया सिलाई का, उस मैचस्टिक का, टू लाइटन अप एनी ऑफ द कैंडल और लाइक दिया और सो. व्हाट यू डू, आप उसका इस्तेमाल करते हैं, ये आपकी पूरी की पूरी मैचस्टिक है और वो मुश्किल से समहाउ यहां पर जाकर के खत्म हो जाती है क्योंकि आपकी दिया सिलाई जल चुकी होती है. आपकी जो जिसको हम जोत या दिया कहते हैं वो जग चुका होता है यहां तक ही. उसके बाद हम उसको क्या करते हैं, बुझा देते हैं. दिस हैपेंड सो रेस्ट ऑफ द स्टिक, ये इतनी की सारी जो है यहां से यहां तक, दिस गेट्स वेस्टेड. तो मेरे साथ भी ये हो रहा था. ऑन डेली बेसिस आई नोटेड इट कि ये इतनी सारी वेस्ट जा रही है. तो इतनी लकड़ी अगर मैं वेस्ट कर रहा हूं, हर घर में 5 से 6 बार सुबह के समय पर दिया सिलाई इस तरह से, ये मैचस्टिक इस तरह से वेस्ट हो रही होगी. हाउ वी कैन स्टॉप दिस? द ओनली सॉल्यूशन वाज कि इट कैन बी स्टॉप्ड इन सच ए वे कि अगर मैं इसको थोड़ा सा मैस्टिक में छोटी DSLI दे दूं, मैं इसको यहीं तक क्यों ना दे दूं, इतने एरिया तक, इतना तो देना जरूरी है, बिकॉज सबकी यहीं तक जलेगी DSLI, ये तो जरूरी नहीं है ना. So somehow up to some height is still a necessity. So what was the solution? कि in a complete match box, a small metal stick or you can say metal point is required, जो कि कुछ ऐसा हो in this structure. We made this structure जिसमें कि यहां बीच का जो एरिया है अप टू द हाफ ऑफ द एरिया इट इज ब्लैंक, सो दैट मैच स्टिक को इसके अंदर डाला जा सके. एट द एंड ऑफ दिस यू शुड हैव ए कैप. यहां पर भी देख सकते हैं आप, ये दिस कैप इज देयर. व्हाई दिस कैप इज रिक्वायर्ड? सो दैट आप इसको होल्ड करके उस मैच स्टिक को वहां से रगड़ करके उसको जला सके. A complete grip should be there. And what is the benefit of this? कि आप इसकी जो हाइट है वो कम कर सकते हैं. सेकेंडली, ये जो आपने स्टील का एक प्लस पॉइंट लिया है, दिस इज ओनली वन इन कंप्लीट मैच बॉक्स, जिससे आपकी ना जाने कितनी ही लकड़ी बच गई. मेटल यू हैव, metal you are available with huge stock, you can say. So by the utilization of that small piece of metal, you can save a lot of wood. So अभी उसको यूज करके देखा मैंने, I made it by the 3D printer. उसको यूज करके देखा मैंने and it was so amazing that I get to save this much of amount of the wood every day at my home. So I get it patented. So a design patent was granted to me in 2020 for this, in which I have to give some of the drawings for this, in which a measurement should be there. कितने mm का क्या एरिया रहेगा, कितनी हाइट का होगा, कितनी विड्थ का होगा, कैप कितनी होगी. We have to give measurement of each and every part. And that you have to make by yourself. चाहे आप अपने किसी कलीग से बनवाएं, किसी स्टूडेंट से बनवाएं, अपने किसी स्कॉलर की हेल्प लें, कैसे भी, बट दैट यू हैव टू गिव. ओके, दैट वाज वन ऑफ द पेटेंट ऑफ मैचस्टिक. सो जब मेरे माइंड में एनी काइंड ऑफ पेटेंट इज देयर एंड आई कैन गो इनटू इट, यू कैन आल्सो क्रिएट बाय योर ओन. ओके, that is one more patent we will discuss with this third patent. That was apparatus for uninterrupted power supply. Normally what happened, हमारे घर में ट्यूब लगी होती है, ट्यूब इज देयर. अभी कभी क्या होता है कि उसका जो स्टार्टर होता है वो खराब हो जाता है, तो वो ट्यूब जो है वो काम नहीं कर पाती है. उस वजह से समहाउ जो उसकी चौक होती है वो मेन चौक खराब हो जाती है, तब भी वो पूरी की पूरी ट्यूब वेस्ट हो जाती है. सो व्हाट इज द सॉल्यूशन? द सॉल्यूशन वाज कि अगर हम उस एक की जगह दो चौक लगा दें, यानी एक बैकअप चौक लगा दें, इसी तरह से जो मेन स्टार्टर है उसकी जगह एक बैकअप स्टार्टर लगा दें. सो वी पुट वन एक्स्ट्रा स्टार्टर and one extra choke. What will be the benefit of this? The benefit will be if one gets failed anyhow, in that case another backup starter or another backup choke will play the role of previous one. इससे होगा क्या, आपकी ट्यूब खराब नहीं होगी, जब आपको उसकी जरूरत है उस समय भी वो काम दे जाएगी. And for that we need is the relay. Relay लगाना पड़ेगा. That will work as the switcher between both of these, backup और main के बीच में इधर और backup और main के बीच में इधर. So it will work as the backup point. The benefit is कि जब भी उसको ठीक करवाना है, you have to call the electrician. He will get correct both of these. Again, you will have a long-lasting tube with you. So that was the one of the patent. This patent was in communication with one of the expert at that time. I discussed it with Dr. Ajay Kumar Sharma ji At the time, he was the vice chancellor of IKG PTU. So I discuss it with them. We do have this solution and we get it patented. What you have to do in that case, you have to power on the system, light intensity. If it gets somehow, dim, then automatically it will be below the threshold. It will go towards the another one. It will go to what? It will go to the another one, the previous one. कि कुछ problem है. Or if it is not, then in that case it will go to the backup mode. तब वो बैकअप की तरफ चली जाएगी. यानी अगर सब कुछ ठीक है तब तो उस तरफ चलता रहेगा. लेकिन अगर कहीं लाइट की इंटेंसिटी लो हो चुकी है, कोई एक चीज जहां से आपको पावर सप्लाई की दिक्कत आ रही है, देन इट विल गो टुवर्ड्स द बैकअप मोड. सो दैट वाज द सॉल्यूशन ऑफ दिस अनइंटरप्टेड पावर सप्लाई, जिससे कि आपको पावर सप्लाई में कोई दिक्कत नहीं आएगी. सो दैट वाज द अगेन द आइडिया ड्यूरिंग दैट टाइम व्हेन माय रूम लाइट वाज ऑफ. सो मेरे को बाद में पता लगा कि स्टार्टर खराब हो गया, जिस वजह से अभी संडे वाज देयर तो कोई भी इलेक्ट्रिशियन आने को रेडी नहीं था. सो कोई शॉप्स ओपन नहीं थी, तो रूम की लाइट ऑफ हो गई थी उस समय. ओके, नाउ दिस एग्जांपल आई हैव केप्ट हियर फॉर द पर्पस ऑफ ओनली just to tell you that you can get patent by any of your research paper as well. This is one of my research paper, which is published in one of the SCI journal, that is wireless personal communication. And if you have any of your good paper, good scheme published at some good place, you can get that patent. Now you must have any one of the good paper with you. So अगर आप चाहें तो उसको पब्लिश करा सकते हैं इन द फॉर्म ऑफ पेटेंट. यू कैन गेट इट डन. बट द पॉइंट इज देयर आर टू मेथड. वन इज आप पहले पेटेंट कराएं, उसके बाद उसका पेपर लिखें. सेकंड थिंग इज आप पहले पेपर लिखें, पब्लिश कराएं, उसके बाद उसका पेटेंट करें. बट बोथ ऑफ दीज मस्ट मेंटेन द गैप ऑफ मिनिमम 0 to 1 day and maximum up to 6 months, because 6 months के बाद आपने ये प्रोसेस शुरू किया, और जैसे ये प्रोसेस शुरू किया, इट मे टेक 1 or 2 months फॉर द फाइलिंग प्रोसेस. तो उसके अंदर 6 months से ज्यादा लग सकते. इट मे टेक 6 months एज वेल. सो मैक्सिमम टाइम पीरियड अलाउड इज 1 year. So if you do have 1 year of time period, you have to start from the 6th month, so that before 1 year you can get it complete. This is the title by which this patent get published, and this is the paper. Paper title and the patent title are somehow different, although theme is same, that you have to securely transmit the data in the underwater environment. So यहाँ पर भी यही theme है, security is being provided. So now question arises कि सर ये हुआ कैसे? How you have done this? A paper was there, आपने paper का किया क्या? I contacted one of the legal firm. He said कि सर मुझे कन्वर्ट करके दे दीजिए अपने इस पेटेंट को in the form of algorithm, whatever you have written. I converted it into an algorithm. He also demanded कि सर प्रोसीजर जो है इसका, जो इसका डायग्राम है वो बना करके दे दीजिए कि कैसे कैसे स्टेप बाय स्टेप क्या काम हो रहा है. I made that one also. Now he said, सर ये किस पे होगा? मैंने बोला सेंसर के ऊपर होगा. He said, okay, if it is on sensor, get it done on any of the sensor. I said, I am not available with the sensor. I do not have that. Purchase करना पड़ेगा, पैसे नहीं है. He said, okay. Another solution was कि आप इसको एक पेन ड्राइव में डालिए, पेन ड्राइव को बूटेबल पेन ड्राइव बनाइए एल्गोरिथम को. वी विल क्लेम दैट पेन ड्राइव एज द पेटेंट डिवाइस. सो दैट पेन ड्राइव वाज एक्टिंग एज द पेटेंट डिवाइस फॉर मी. So that was the patent done by this paper. So if you have any of the paper that's published in the last 6 months or so, you can have the patent of that paper as well. आपको कोई नया पेटेंट करने की जरूरत भी नहीं पड़ेगी. We get it done by one of the legal firm. Here it is mentioned as Tarun Khurana. तो खुराना firm was there, जिसकी हेल्प से हमने ये पेटेंट करवाया. Okay, this was another patent. इसकी भी स्टोरी बड़ी इंटरेस्टिंग है. We utilized this invention for the project. we filed a project in IIT Delhi. So we presented our idea over there. The idea was much likely to be accepted by all the jury members. One of the jury members said that, is your idea patented? We said, no, it is not yet patented. We will work on it. Then he said, if it is not patented, if it is good, like I'm saying it is good, I will reject your idea over here. And maybe by this idea, I will get a patent before you and I'll claim that this is my idea. बोले ये तो आइडिया चोरी करना हुआ. बोले हाँ, yes, ये आइडिया चोरी करना ही हुआ. I'll do that. How you will prove it? There is no proven source for this because you have not made any kind of design of this. You have not demonstrated कि आप इसमें क्या यूज करेंगे in writing. You just said कि हाँ हम एक डिवाइस बना रहे हैं जो कि सीड को जो है एनालाइज करेगी. That's it. जो सीड होता है, जो किसी भी तरह का सीड हो सकता है, it can be utilized by a farmer for any of the crop. So you will analyze that कि इसकी capacity क्या है, कितनी growth इसकी हो सकती है. You have not made any kind of design. You have not get it patented. We came into this idea and for the very next day we made this design for the 3D view. We tried to get it patented as soon as possible कि इससे पहले हमारा आइडिया चोरी ना हो जाए. So हमने इसको पेटेंट कर लिया and this is the certificate that we obtained from the patent office that it is granted now. It was done on 15th of April 2021. So what is there in this idea? That you have to put a seed in this tray, whatever the collection of seed you have in your hand, जो कि farmer अपने कहीं से भी खरीद करके लेके आया है. This tray will be inside this box. Inside, after putting it inside, this lid will get closed. Over and above this lid, we do have some touch screen panel buttons. Over these touch screen panel buttons, we will analyze it on the basis of machine learning algorithms that ये जो हमारा seed है इसकी growth कितनी हो सकती है. We later on utilize the image processing, the deep learning algorithms as well, but we first of all get it patented. So सबसे पहले तो patent करवाने का काम किया था हमने इस idea को. So that was somehow told by us by one of the jury member in that group कि आप इसको पेटेंट करवा लीजिए वरना आइडिया अच्छा है, हम लेने वाले हैं इसको पर. Okay, this is one of the another utilization of the idea that came into my mind during one of the working with the research scholar. He was Mani. I was working with Mani. Mani said, sir, there is a problem in the washrooms. I said, what is the problem? Whenever someone pees during that time period, वो कुछ खा रहा है, चिंगम खा रहा है तो चिंगम इसके अंदर फेंक रहा है, वो कुछ भी मतलब कागज भी फेंक रहा है इसके अंदर. एंड द प्रॉब्लम इसकी जो स्वीपर होता है उसको ये सारा साफ करना पड़ता है. दैट इज somehow problematic. So what is the solution? The solution was कि सर अगर इसको हम ट्रे की फॉर्म में यहाँ डालें और ट्रे को जब चाहे बाहर निकाल करके उसको अलग से निकाल दें, so it will be removed easily. In that case ये use and throw वाला काम हो जाएगा. We said yes, it is good idea. Or we can get it by the help of the thermocol like material as well. तो उसका भी utilization कर सकते हैं. So we get it patented. The idea was very much simple कि लोग जो हैं वो उसको मिसयूज कर रहे थे तो हमने उसको ठीक करना था. तो कैसे करें, ऐसे कर सकते हैं और उसी को पेटेंट करा लिया. And we call it as wall mounted mesh urinal pot. Okay, now जो भी घर पे कपड़े धोते हैं, महिला या पुरुष कोई भी हो सकते हैं, जो भी कपड़े सुखाते हैं उनको ये प्रॉब्लम शायद फेस करनी पड़ती होगी. इवन नाउ डेज एज वेल. प्रॉब्लम क्या होती है, छत पर कपड़े सुखा करके आए या बालकनी में कपड़े सुखाए, आफ्टर दैट सडनली मौसम खराब हुआ, बारिश शुरू हुई एंड आपके जो कपड़े सूखे हुए थे वो फिर से भीग गए. दैट इज द प्रॉब्लम वी फेस. सेम प्रॉब्लम वाज देयर दैट वी वर डिस्कसिंग विद आवर कलीग्स. Then we thought of this solution. एक ने बोला अगर उसके ऊपर कोई जैसे ही बारिश आए और अम्ब्रेला लग जाए, एकदम से ये अम्ब्रेला खुल जाए कुछ इस तरह से, तो जो भी कपड़े इसके नीचे लटके हुए हैं, जैसे हम अम्ब्रेला के नीचे अपने आप को पानी से सेव कर लेते हैं, दोज क्लोथ्स कैन ऑल्सो गेट सेव्ड. द आइडिया वॉज गुड, बट द प्रॉब्लम वॉज कि सेंसर के पता करने पर जैसे ही बारिश की बूंदें आई, ये खुल जाएगा छाता, द अम्ब्रेला वॉज गेट ओपन्ड. बट द प्रॉब्लम वॉज कि क्या ये बंद होगा? यस, वी पुट इट वन मोर सेंसर. व्हेन दिस drops was not there, then it will get automatically close. Or in emergent situation, a button was also placed over there by which opening or closing of the umbrella can get also happen. ऑटोमेटिकली काम ना करे, सेंसर काम ना करे, खराब हो गया तो भी उसका सोल्यूशन ये बटन कर देगा. One problem was still there. Sir, sun is in this direction, इधर के कपड़े तो सूख जाएंगे, what about another area? So we made it revolving stand. By this revolving stand, इधर के कपड़े भी सूख रहे हैं, उसके बाद ये थोड़ी देर बाद, मे बी आधे घंटे बाद घूम के इस तरफ आ गया था, तो इधर के कपड़े भी सूख गए. So by this revolving stand, the solution was done कि अब हमारे कपड़े किसी भी साइड के हों, चारों तरफ से सूख जाएंगे. बारिश से भी बच गए, कपड़े भी सूख गए, ऊपर जाकर के उनको देखने की जरूरत नहीं पड़ी. Somehow a solution up to an extent for the problem of वो जो भी गृहिणियां हैं जिनको ये प्रॉब्लम फेस करनी पड़ती है कि कपड़े सुखाने के लिए रखे थे, उल्टा गीले होकर के आ गए. That was one of the solution. Okay, this is one more solution that normally the ladies face. What is the problem? The problem was one of my colleague at that time, she said कि सर मुझे अभी अभी बेबी हुआ है कुछ समय पहले, और इन द मिडनाइट, कभी 11 बज रहे हैं, 12 बज रहे हैं, जब हम सो चुके होते हैं, बेबी को भूख लगती है, और उसकी फीडिंग के लिए मुझे जब भी दूध बनाना पड़ता है या कुछ करना पड़ता है इस तरह का, तो मुझे उस समय बहुत समय लगता है, नींद भी पूरी तरह से खुल जाती है, और इसीलिए मतलब यूनिवर्सिटी के अंदर आने पर भी नींद ढंग से नहीं आती. सो व्हाट वाज द सॉल्यूशन? वी थॉट ऑफ द सॉल्यूशन. सी सेड कि अगर कुछ ऐसा हो जाए कि हम सिर्फ एक सेंसर लगाएं कहीं किसी बॉटल के ऊपर, उससे जो मिल्क है वो प्रोसेस हो जाए, उससे जो उसका स्टेरिलाइजेशन है वो प्रोसेस हो जाए, वो उसको थोड़ा सा रोटेट भी कर दे, ये 3 काम हो जाए. जैसे मिक्सी के अंदर रोटेशन होती है, ऐसे थोड़ी सी रोटेशन हो जाए हल्की सी, थोड़ा सा वो उसको गर्म कर दे. अगर ये सब रोड की हेल्प से हम इसको गर्म कर दें, अगर ये सारा सॉल्यूशन हो जाए, तो मुझे रात को जागना नहीं पड़ेगा. सो दैट वाज द सॉल्यूशन केम इनटू आवर माइंड. इस सॉल्यूशन पे हमने काम किया एंड वी मेड दिस ऑटोमेटिक फीडिंग इन विच ए सेंसर इज प्लेस्ड. By the help of this sensor, she just have to put hand on the sensor, the touch sensor, or you can say button, after which this complete feeding bottle gets started its work. इसने फीड बना के दे दी. We are just putting complete unit aside, and by having the milk ready for the baby up to the required temperature, we are just feeding the baby. So this was one of the another solution that came to our mind. Okay, this was another patent that is somehow all in one stand for the office table. You can see the simplicity. The main inventor for this was Dr. Atul Garg. He said कि सर हम ऑफिस के अंदर इस तरह का कप होल्डर भी चाहते हैं, इस तरह की ड्रॉर्स भी चाहते हैं, कुछ ऊपर पड़े रहे, कुछ पेन्स रख सकें वैसा भी चाहते हैं, कुछ छोटी मोटी फाइल्स या नोटबुक्स चाहते हैं, कुछ स्लिप्स वो भी रख सकें. सो वी नीड ऑल काइंड ऑफ दिस इन वन. सो व्हाई नॉट टू क्रिएट समथिंग लाइक दिस. ऐसा हमने क्रिएट किया, वी गेट इट पेटेंटेड. सो आप कुछ भी बनाइए, दैट शुड बी न्यू, that should solve a purpose जो कि अभी तक किसी ने सॉल्व नहीं किया है, and you can get it patented. आप इसको पेटेंट करा सकते हैं. So that is possible if you have anything in your mind. Okay, ये बड़ा इंटरेस्टिंग पेटेंट था. ये 2019 में हमने पेटेंट किया था. हम बड़े आलसी थे और 3 से 4 लोग थे जो बड़े आलसी थे. So द प्रॉब्लम वॉज कि हम घर गए, हम चाहते हैं कि हमारे जो शूज हैं वो भी कोई और ही ब्रशअप करके दे दे, हम ब्रशअप नहीं करना चाहते थे. फिर क्या करें? तो इसके लिए एक रैक बनाया गया। वी सेड कि रैक तो हमारे पास है, इट विल बी एन ऑटोमेटिक रैक। इसके अंदर होगा क्या, कुछ इस तरह से सेटलमेंट होगी कि ये ऊपर की तरफ कमानी जाएगी और रोटेट होकर के नीचे की तरफ से फिर से आ जाएगी। सो व्हाट विल बी द सॉल्यूशन? सॉल्यूशन विल बी कि हम यहाँ पर अपने शूज रख देंगे इस एरिया में। शूज रखने के बाद ये अपने आप जहां पर भी खाली जगह होगी, आपकी चप्पल, जूते, जो भी कुछ है उसको उसी जगह पर प्लेस कर देगा। वी मेड इट फॉर 12 प्लेसेस, यू कैन मेक इट फॉर लॉन्ग, फॉर मोर और फॉर लेस। इसी के विद रिस्पेक्ट टू अगर आपको कुछ क्लीनिंग करवानी है, कुछ भी करना है, यू जस्ट प्रेस ए बटन कि 2 नंबर पे, ये ट्रांसपेरेंट रैक था, कि 2 नंबर पे जो भी कुछ रखा हुआ है उसको ये क्लीन कर दे। सो व्हाट विल बी डन, ये कमानी जो है रोटेट होती हुई नीचे आएगी, 2 नंबर शूज विल गेट आउट, यहां पर रखा जाएगा। उसके बाद इसकी लेफ्ट और राइट मूवमेंट होगी, जहां पर भी ब्रश होंगे वो इसके ऊपर अपना काम करके इसको क्लीन कर देंगे। बाय द टाइम यू नीड द शूज इट विल गेट क्लीन अप, और आपको क्लीन शूज सुबह मिल जाएंगे जो कि आपने रात को या शाम को रखे थे इसमें। तो आलसी लोगों के लिए सॉल्यूशन वाज देयर। ओके, normally it is the problem ki sir, how to see that this kind of procedure or the patent we can do. So I'm going to show you a screen जहां पर आप अपने पेटेंट के बारे में सर्च कर सकते हैं कि उसका स्टेटस क्या है। नॉर्मली यही नहीं पता लगता कि हमारे पेटेंट का स्टेटस है क्या। सो यू कैन सर्च वट एवर इज योर पेटेंट कि इसका सोल्यूशन और इसका इस समय करंट स्टेटस है क्या। सो दिस इज वन ऑफ द साइट जो कि IPRsearch.IP इंडिया, इंडियन गवर्नमेंट की साइट है ये। यू हैव टू पुट सम कैप्चा ओवर हेयर जो कि इन्होंने मैंडेटरी किया हुआ है, एंड यू हैव टू पुट द application number for any of your patent, but this patent should be a utility patent। अब मैं अपनी कोई पेटेंट यहां से ले लेता हूं और सपोज कीजिए मैं इस पेटेंट को यहां पर सर्च करता हूं टू शो द स्टेटस। नाउ स्टेटस इज शोन एज इट इज फाइल्ड टिल नाउ। अभी इसके बाद ये पब्लिश होगा, फिर इसका आरक्यू होगा, फिर एग्जामिनेशन होगा, फिर ये डिस्पोज ऑफ होगा, मतलब या तो ये ग्रांट होगा, ये खत्म हो जाएगा, राइट। इन द सेम वे इफ यू वांट टू चेक एनी ऑफ योर डिजाइन पेटेंट, देन आप उसको भी चेक कर सकते हैं बाय दिस साइट search.ipindia.gov.in। दिस इज द वेबसाइट टू चेक आउट फॉर एनी ऑफ योर डिजाइन पेटेंट, अपना या किसी का भी, कोई भी चेक कीजिए, नॉट ए प्रॉब्लम। अब क्वेश्चन इज कि सर डिजाइन पेटेंट जो होता है, हाउ यू चेक इट, व्हाट इज द प्रोसीजर कि ये डिजाइन पेटेंट है। नॉर्मली डिजाइन पेटेंट का जो नंबर है दैट विल बी समथिंग लाइक दिस, लास्ट में -001, समथिंग लाइक दिस। वेयर एज यूटिलिटी पेटेंट होगा वो इस तरह से लॉन्ग लास्टिंग सा होगा, मतलब लंबा सा नाम लिखा हुआ होगा उसका, लंबा सा नंबर होगा उसका, समथिंग लाइक दिस। दिस विल बी द काइंड ऑफ यूटिलिटी पेटेंट। नाउ डिजाइन पेटेंट को चेक करना है, शो द स्टेटस। नाउ इट इज शोइंग कि कौन कौन इसके एप्लीकेंट है, इसका CBR का नंबर क्या है, एप्लीकेशन नंबर क्या है, इसकी CBR की यानी पब्लिश जब हुआ इसकी डेट क्या है, क्या हुआ, कौन से जर्नल के अंडर हुआ, बिकॉज पेटेंट के विद रिस्पेक्ट टू हर एक के जर्नल नंबर होते हैं। सो जर्नल नंबर विल बी देयर, एंड कौन सी डेट को ये एक्चुअली ग्रांट हुआ, इस जर्नल के अंदर कब आया, सो दैट विल ऑल्सो बी शोन ओवर हियर, राइट। सो दिस इज द वे टू चेक अबाउट योर पेटेंट की व्हाट इज द स्टेटस। किसी का पब्लिश हो सकता है कि कोई पब्लिश स्टेज में चल रहा हो, अभी ग्रांट ना हुआ हो, किसी के अमेंडमेंट्स चल रही होंगी, किसी का FER रिप्लाई फाइल किया होगा। सो इन एनी ऑफ द केस यू कैन चेक कि आपका पेटेंट का स्टेटस है क्या। नाउ आई एम गोइंग टू एंड अप माय स्लाइड्स विद इन 1 or 2 minutes that we do have some of the future possibilities। अब आप जो है वो पेटेंट किस तरफ कर सकते हैं, फ्यूचर एस्पेक्ट को देखते हुए आप इनमें से किसी भी तरफ कर सकते हैं, बिकॉज वी डू हैव द पॉसिबिलिटी ऑफ रोबोटिक्स नाउअडेज। तो आप हो सकता है अपना कोई एक रोबोट डॉग बना लें, उसको पेटेंट करा लें, अभी तक जो कि नहीं हुआ है। आप हो सकता है घर में कपड़े धोने की मशीन का कोई रोबोट बना लें, उसको पेटेंट करा लें। आप हो सकता है किसी तरह का कोई एल्गोरिथम सजेस्ट कर दें फॉर दिस काइंड ऑफ मशीन जो कि आप हॉस्पिटल में यूज कर सकते हैं, डिश वॉशर मशीन के विद रिस्पेक्ट टू आप कोई पेटेंट बना सकते हैं, आप कोई नई तरह का ड्रोन बना सकते हैं, उसके अंदर नया फीचर लगा सकते हैं, इनोवेटिव हो, उसका पर्पस इनोवेटिव हो, उसका बना सकते हैं। होम डिलीवरी के लिए कोई रोबोट, कोई ऑटोनोमस कार के लिए बना सकते हैं, कोई घर की सफाई के लिए किसी तरह का कोई एपरेटस, कोई एल्गोरिथम बनाना चाहे वो बना सकते हैं। शेयर मार्केट की प्रिडिक्शन का भी बना सकते हैं। नाउ डेज यू सी कि शेयर मार्केट में बहुत लोग इन्वेस्ट करते हैं, सो उसके लिए आप कुछ पेटेंट कराना चाहें, उस पर अपना कॉपीराइट बना करके उसको मार्केट में थ्रू करना चाहें, वो भी कर सकते हैं। जो ओल्ड पीपल हैं, चलने में उनको प्रॉब्लम होती है, उसके लिए कुछ नई इन्वेंशन करके, कुछ नया इन्वेंट करके, कुछ ऐसा कम प्राइस का नई इनोवेशन के साथ कम जो लागत में उनको मिल सके, ऐसी कोई डिवाइस बना सकते हैं जिससे उनको चलने में मदद मिले। कोई आप अपना नया रोबोट क्रिएट कर सकते हैं, कोई AR VR की फैसिलिटी क्रिएट कर सकते हैं। सो नाउ दीज वर द फ्यूचर पॉसिबिलिटीज दैट यू कैन क्रिएट फॉर एनी ऑफ योर पेटेंट। ऑल्सो एक पेटेंट था, मुझे अच्छे से याद है, बड़ा बड़ा सिंपल पेटेंट था। द पेटेंट वाज कि एक मदर जो है वो डेली बेसिस पे अपनी बेटी की गुत्त बनाती थी, कहते हैं ना वो पीछे बाल जो है, अपनी बेटी को स्कूल जाने में डेली गुत्त बनाती थी। सो उसको गुत्त बनाने में सुबह डेली 5 से 10 मिनट लग जाते थे। तो उन्होंने कहा, क्या करा कि कुछ ऐसा सोल्यूशन हो कि उसके बाल खुलने हैं बेटी के, और वो जस्ट बालों को एक रैपिंग वे में एक एपरेटस कुछ मिल जाए, उसके अंदर जस्ट एक बार डालें और वो उसकी गुत्त बना करके फटाक से उसको दे दें, जिससे उसकी मदर का टाइम बच जाए और उसकी गुत्त बड़ी अच्छे से आराम से बन सके। सो दैट वाज वन ऑफ द पेटेंट। एक बंदर भगाने का पेटेंट किया गया था बाय वन ऑफ माय कलीग इन चंडीगढ़ यूनिवर्सिटी। सो बंदर भगाने का भी पेटेंट हो सकता है। सो इट इज अप टू यू कि आप किस तरह का और क्या पेटेंट करने वाले हैं। देयर इज नो लिमिट फॉर योर इन्वेंशन इन द केस ऑफ पेटेंट इफ यू वांट। So that was all from my side. If you have any of the query, I'm open to that.
Good evening, sir.
Yes, ma'am, please.
Sir, when our paper get published, but then all the rights are reserved with the publishers, then how can we get it patented?
Exactly. So like in my paper, I told you that you do have your paper with you. You just have to use the information of algorithm. That algorithm, when you are putting it in some of the, say, another medium here we are saying as the pen drive में आपने डाल दिया उसको एल्गोरिथम को. Now that pen drive is bootable pen drive, which is something somehow different than that paper. Now it is not under the copyright of that publisher. Firstly this. Secondly, पहले जो आपने यूज किया था उसका एरिया और क्राइटेरिया अलग था. अब इसके विद रिस्पेक्ट टू आपने उसमें अगर एक भी चेंज कर दिया है, माइनस की जगह प्लस कर दिया, प्लस की जगह माइनस कर दिया, तो भी वो आपका एल्गोरिथम उससे अलग ही माना जाएगा. That will not be under the copyright violation.
We have to change it slightly.
Very slight change is sufficient. Very slight change. Suppose one change was like कि आपने उसको पेन ड्राइव में डाल दिया और पेन ड्राइव बूटेबल बना दी. So that was also a change कि आपने अब पेन ड्राइव को बूटेबल बना दिया. That was not previously.
ठीक, thank you, sir.
Yes, please. I am open to the queries because my ultimate goal is कि आप सभी लोगों का अगर एक भी पेटेंट हो सके अगले 2 महीने में, then my this session will be fruitful.
Any other? If want to ask any question?
Session was very, very interesting, sir.
Thank you,
Yes,
ma'am.
ma'am.
Thank you.
Knowledgeable.
So thank you very much.
I think there is no question, sir.
Thank you. Thank you.
Thank you very much, sir. for very informative and interesting session. Thank you for your invaluable contribution to the success of our seminar. Now it's time for feedback by participants. I request to delegates, please give your valuable feedback about this seminar. Session is now open for feedback by participants.
Ma'am, this is Bharat Chavda. May I speak up?
Yes, sir. Yes, sir. Welcome,
Very
sir.
good evening, ma'am.
Good evening.
I am into this conference since morning today and have been hearing the presentations from knowledgeable guests, especially Dr. Sahani, Dr. Pragati, and during the technical session, I was in session track number 4. There I also heard some beautiful comments from Dr. Jaydeep. Then especially the last session by Dr. Nitin Goyal was so inspiring that we got the feeling like we have wasted many years of our lives without filing a patent. So this idea is the way of speaking up and giving so many real life examples are really inspiring us to do something. I really commend the conference organizers for selecting such high quality papers and the presentations. Those are really valuable, and those also gave us some insight into the IPR. And one more thing, I also appreciate the seamless organization and the sequence of events, the parallel tracks that you conducted. So that is really amazing and good. And I also express my gratitude for this opportunity to participate in this conference and also give a constructive feedback. Thank you so much, ma'am.
Thank you so much, sir. Now, I request Dr. Ashok Kumar Kashyap, Department of Computer Science, International Center for Distance Education and Open Learning, HP University, Shimla, Himachal Pradesh, for feedback of this event.
So, good afternoon. First of all, I want to congratulate Arya Kanya Mahavidyalaya, Shabar Markanda, Haryana, on the successful completion of a very informative and knowledgeable one-day national seminar on IPR in the digital era. So, the seminar provided valuable insight into the emerging trends of IPR within the digital landscape. The speakers offer practical examples and case studies which enrich our understanding of IPR in this era. Especially Dr. Rima Sahani, Dr. Pragati Agarwal, who they elaborated well the concept of IP strategies in digital age and digital licensing model. Miss Dr. Reena Sahni explained the process of filing patents and what are the key constraints that should be considered before filing a patent. In the last session, Dr. Nitin Goyal has also explained very beautifully about his patents. And he also mentioned that good discussion or good ideas come at bad times. That is also applicable in my case as well. So the presentation session was also very interactive and question answer segment fostered meaningful discussion. The seminar provided an excellent platform for networking with professional experts in the field of IPR. And lastly, the event was very well organized. It was very smooth. Logistic arrangement was very good and timely arrangements were done. The technical setup contributed to a seamless experience for the participants. So we will look forward for the future edition and continued exploration for this important subject in future. Thank you.
Thank you so much, sir. Now, I invite co-convener, respected Ma'am Dr. Hema Sukeja for presenting report of the seminar.
Thank you, Dr. Rosie.
Excuse me, Hema, 1 minute. Madam Sucheta has raised hand.
Yes, ma'am. Hanji.
Oh, sorry, ma'am. Sorry.
It's okay, Hanji.
Continue.
Okay. So good evening to all present here. I, Dr. Hema Sukhija, Assistant Professor in Mathematics and co-convener of this seminar, feel privileged to present report of this national seminar. DHE approved one-day multidisciplinary national seminar on innovative trends of IPR in digital era was organized by Arya Kanya Mahavidyalaya, Shahabad, Markanda on March 19, 2024. And the seminar aimed to delve into the dynamic landscape of intellectual property rights in the digital age, exploring the latest trends and shifts in strategies, regulation, and challenges. It is commenced with an overview of the digital transformation impacting various sectors and its implications for intellectual property rights. Now, this seminar was started at 10 a.m. with the Saraswati Vandana and lamp lightning. And then welcome address was delivered by our principal, Dr. Aarti Trehan, and the dignitaries were present: Professor Naresh Kumar Vats, Dean School of Law, Galgotias University, Greater Noida, Uttar Pradesh; management members, Ms. Reema Sahani and Ms. Pragati Agrawal from Innovative Technology Transfer Office, IIT Delhi, and Dr. Nitin Goyal ji from Department of Computer Science and Engineering, Central University, Mahendragarh, Haryana. Then during this seminar, opening remarks and theme of the seminar was presented by Dr. Swati Atri, convener of Research and Innovation Cell, and of the seminar also. She highlighted the theme of the seminar and said that seminar aimed to explore the evolving landscape of intellectual property rights in the context of rapid digital advancement and to discuss innovative strategies for protecting intellectual property in this digital era. She also welcomed all the guest research experts, delegates, expressed his gratitude for the President, Shri Ramlal Gupta ji, and members of Managing Committee, our Principal, Dr. Aarti Trehan, and DHE for giving an opportunity to organize this seminar on the theme Innovative Trends of IPR in Digital Era. Various faculty members and students from different states were invited in the seminar. The chief guest of the inaugural session of the seminar was Professor Dr. Naresh Kumar Vats, Dean School of Law, Galgotias University, Greater Noida, Uttar Pradesh. The keynote address was also given by Sir Dr. Naresh Kumar Vats ji. He shared his work and talked about digitalization of intellectual property rights and traditional knowledge. He highlighted the challenges and opportunities presented by digitization, including issues of copyright infringement, data protection, and the rise of digital platforms. The talk was really very influential and full of words of wisdom and knowledge. And then in the first technical, vote of thanks was presented by Dr. Poonam Sivaj, co-convener of this seminar. And after then, in the first technical session that was started with an invited talk by Ms. Reema Sahani, Head Innovative Technology Transfer Office, Foundation for Innovation and Technology Transfer, IIT Delhi. Her talk was on IP strategies in digital age, and attendees gained insights into navigating IP strategies very effectively in today's dynamic digital landscape. In the next session was on digital licensing models by Ms. Pragati Agrawal. She is project manager in ITTO, FITT, IIT Delhi. And the discussion emphasized the importance of tailoring licensing strategies to meet customer needs while maximizing revenue streams and complexities of digital. And she has also explained how navigating the complexities of digital licensing and optimizing strategies for sustainable growth in the digital economy. And In the afternoon session, presentation was given by 144 participants in 7 parallel sessions, and we had total 152 participants from the different states, and they are from 10 different states. And the states are Himachal Pradesh, Tamil Nadu, Uttarakhand, Maharashtra, Chandigarh, Rajasthan, Gujarat, Delhi, Punjab. And they have attended this seminar and presented her views regarding the role of emerging technologies such as AI, blockchain, Internet of Things in reshaping the landscape of intellectual property rights. And case studies and examples were also presented to illustrate how these technologies are affecting traditional IP frameworks and necessitating new approaches to IP, intellectual property rights. And after then, we are in the valedictory session. And as all of you are in this valedictory session, and the chief guest of the valedictory session was Dr. Nitin Goyal, Assistant Professor, Department of Computer Science and Engineering, Central University, Maharashtra, Mahendragarh, Haryana. And he presented his work on IPR, a practical solution. And sir, you have really explained, in a very practical way, and aware us how we can patent each and everything by taking the real life examples. If we can do one, you have given a lot of ideas. How can we patent each and every aspect, each and every, from the morning to evening, we can judge how can we do the patenting. You will give us a lot of ideas, and really, hopefully after this seminar, most of the people think about this, how can we patent our work. So thank you very much, sir, for this. Really wonderful talk. And then feedback of the seminar was presented by Mr. Gaurav Chawla ji. And Dr. Ashok Kashyap. He is Assistant Professor from International Center for Distance Education and Open Learning, HP University, Shimla. And the whole program from the morning, you can see here, the whole program was compared by Dr. Rosie, Organizing Secretary of the seminar. The vote of thanks will be given by Dr. Poonam Sivaj, co-convener of this seminar in the valedictory session. And with the effort of all teaching and non-teaching staff, organizing committee of the seminar, hopefully the program wrapped up around 5:30 p.m. And in nutshell, we can say this national seminar on innovative trends of IPR in the digital era served as a platform for stakeholders to exchange knowledge, share best practices, and chart a way forward for effective IP protection in an increasingly digitalized world. By embracing innovation and collaboration, participants reaffirmed their commitment to safeguarding IPR while harnessing the opportunities presented by the digital revolution. So thank you very much. Thank you.
Thank you very much, ma'am. Now, I invite respected ma'am Dr. Poonam Sivaj, co-convener of the seminar, for vote of thanks.
Thank you, ma'am Rosie.
Thank you.
Good evening, Honorable Chief Guest of valedictory session, Dr. Nitin Goyal, Department of Computer Science and Engineering, Central University, Mahendragarh. Respected management members, respected Principal Ma'am Dr. Aarti Trehan, respected guests and principals of various colleges, and dear participants. I, Dr. Poonam Sivaj, Coordinator IQAC and co-convener of this DGHE-approved National Seminar on Innovative Trends of IPR in Digital Era, feel highly privileged and honored for being asked to propose a vote of thanks on behalf of Arya Kanya Mahavidyalaya Shahabad Markanda and its entire fraternity, especially management, Principal Ma'am, IQAC, and Research and Innovation Cell. So first of all, I would like to extend my sincere and hearty thanks to Dr. Naresh Kumar Vats, chief guest of our inaugural session of this seminar, who has enlightened us on the topic of webinar, that is Innovative Trends of IPR in Digital Era, and shared his precious knowledge and time with us. So thank you, sir. Now I would like to thank resource person of our technical session, Madam Rima Sahani. She's our alumni also, for sharing her views on IP strategies in digital age, like nature of intellectual property, how IPR help authors, creators, developers, and owners to get recognition of their work. So thank you, Ma'am Rima. I would also like to thank Madam Pragati Agarwal, second resource person of our technical session. She explained technology transfer, business facilitation, forging linkages, significance and types of technology transfer, and its areas of application in a very nice manner. So thank you, ma'am. Thank you, ma'am, again. Now, I would like to extend my sincere and hearty thanks to our worthy chief guest of this valedictory session, Dr. Nitin Goyal. We are highly grateful to you, sir, for accepting our invitation, sir. You have shared your precious knowledge and time with us, giving wonderful, informative, valuable, and knowledgeable session. You have explained the process of patents in detail, also suggested to write the idea whenever it comes to your mind. So thank you, sir, guiding all the participants in such a nice manner. You have successfully raised the levels of all the participants, and you have showed the road ahead to all of us for patent registration. So thank you, sir. You really inspired all the participants. Thank you. Thank you very much, sir. I am also, now I would like to thank all the guests and participants and principals of various colleges for being with us in this seminar. Special thanks to all the participants whose huge participation and presence made our this national webinar a grand success. So thank you all the participants. Thank you very much. Also thankful to Dr. Bharat Chabda and Dr. Ashok Kumar Kashyap for sharing feedback of the seminar. Thank you, sir. Thank you very much. Or I would now I also wish to express our gratitude to our managing committee members. I would also like to thank our principal ma'am, Dr. Aarti Trehan, for providing all sort of help, permissions, guidance, and motivation and cooperation in organizing this event. Thank you very much, ma'am. We are also thankful for press for taking coverage of today's event. At last, I express my deep sense of gratitude to all the members of organizing committee who have worked day and night for making this seminar a grand success. So thank you all the members. Also special thanks to our technical and supporting staff members for their cooperation and making this program successful by putting their special efforts. So thank you all of you. Thank you once again. Thank you.
Thank you very much, ma'am. Delegates, please note that feedback form has been shared with you in the chat box. There should be no mistake in feedback form so that the certificate becomes correct. As we conclude our seminar, let us stand up for the national anthem. Thank you. Thank you all. Thank you all.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मांगे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे
Thank you. Thank you all.
We will share the feedback link in the group also.